Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which, excuse me, for which a recorded vote for the ayes and nays are ordered. I would like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible, as quickly as we can. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as the committee markups, except when recognized to speak. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2377, to authorize the issuance of extreme risk protection orders.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, is an important measure to help address gun violence in America. The bill authorizes federal courts to issue an Extreme Risk Protection Order, or ERPO, temporarily removing firearms from a person in crisis and preventing them from purchasing firearms after making a determination that there is evidence demonstrating that the person poses a significant danger of injuring himself, herself, or others. We know that extreme risk laws save lives. We have witnessed their effectiveness in state after state, beginning in 2016 when California passed the first such law. Since then, 18 other states and the District of Columbia have enacted similar laws. Our consideration of this federal mechanism today is an explicit acknowledgement that gun violence and mass shootings unfortunately have no bounds. Every jurisdiction in this country has been touched by gun violence. This federal provision would ensure that law enforcement, as well as family members and household members of those who pose an immediate risk of harm to themselves or others, have consistent access to courts to seek ERPOs and would enable continuity of enforcement of ERPOs across state lines. Federal courts have long been bastions of due process, and accordingly, this legislation includes strong due process provisions that strike the appropriate balance between protecting the rights of the gun owner and ensuring community safety. For example, the bill would allow an order to be issued pursuant to an ex parte proceeding, but only for a brief duration of 14 days. In the proceeding, a neutral federal judge must determine whether there is probable cause to believe that the gun owner poses a risk of imminent personal injury to himself, herself, or another individual by purchasing, possessing, or receiving a firearm or ammunition, and that the ERPO is necessary to prevent the injury. During that 14-day time period, the court will determine, after a hearing that includes participation by the gun owner, who may be represented by counsel, if a long-term order lasting up to 180 days is appropriate under a clear and convincing evidence standard. The petitions for these orders require a signed affidavit sworn to before the court, explaining in great detail why the petitioner believes that the gun owner poses a risk of imminent injury to himself, herself, or another person by purchasing, possessing, or receiving a firearm or ammunition. If the court issues an extreme risk protection order, the gun owner would have to surrender the firearms and ammunition temporarily for the duration of the order. Also for the duration of an order, the fact of the gun possession and gun purchase prohibition would be placed in the NICS database used by the Brady Act background check system so that gun dealers would not be legally allowed to sell guns to someone subject to an order while the order is in effect. This bill provides a sensible means by which an individual who is exhibiting dangerous behaviors can be prevented from possessing or purchasing firearms before tragedy strikes. According to one study, over 50% of mass shooters exhibited some warning signs before the shooting. The bill before us authorizes people who have serious concerns that someone they know poses an extreme risk to themselves or others to take the action needed to save lives. Today, this committee has the opportunity to build on measures that the House has already passed, including H.R. 8, the Bipartisan Background Checks Act of 2021. It is critical that we enact all of these bills. Every day in America, on average, 34 people are murdered with a firearm, and more than 183 people are injured in an attack. But while no other country in the industrialized world would tolerate such statistics, in fact, gun deaths in most of those countries barely crack triple digits annually. In the United States, it is accepted as a grim reality. Every day that we do not act is another day that families will mourn the loss of a loved one. Every day that we do not act is another day that our streets, our schools, and our houses of worship are less safe because dangerous weapons are in the hands of individuals who should not be legally permitted to possess them. H.R. 2377 would take meaningful steps to prevent gun violence tragedies in our communities, while at the same time protecting the due process rights of those individuals in crisis. I thank our colleague, Representative Lucy McBath, for championing this effort by introducing this bill, and I urge all of my colleagues to support this important legislation. Before I recognize the ranking member, I want to remind members once again that masks are required in all enclosed spaces. They must cover both your mouth and your nose. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Last week it was parents. This week it is gun owners. Remember what we learned last week in that important hearing. We learned Democrats supported the Department of Justice setting up an open, dedicated line of communication for threat reporting. As we said last week, a snitch line on parents. The Attorney General engaged the National Security Division in this effort, and the only evidence the Department of Justice had for taking these actions was the letter from the National School Board Association, which 24 hours after our hearing last week, they apologized for. And it wasn't just your average apology. It was, we regret and apologize for the letter. There was no justification for the language included in the letter. We apologize for the strain and stress this situation has caused you and your organization. 2 apologies in 1 paragraph. I don't know if I've ever seen that. So last week it was going after parents based on a letter that has been apologized for in a way I frankly haven't seen around this town. This week, Democrats are going to take away law-abiding Americans' Second Amendment rights. Here's what this bill would do. It would deprive individuals, people who have neither been accused nor committed any crime, of their firearms without due process of law. By depriving individuals of their property and rights without having been charged, arraigned, or convicted of a crime, this bill violates the constitutional due process rights set out in the 5th and 14th Amendments. This bill would flip the presumption of due process on its head. The accused person is deprived of the opportunity of defense or the ability to cross-examine the accuser. Individuals faced with an ex parte order would be forced to spend a considerable amount of time and resources on defense without ever being accused of a crime. And if the individual mounts a successful defense, the difficulty of having the seized property returned is a huge burden. Think about it. This bill requires a firearm owner to turn over the firearms or sell them within 48 hours. But there's no requirement in the bill for the government to return the firearms once the order expires or is no longer in effect. This means that individuals who seek the return of their property must take independent and expensive legal action to have the property returned by the federal government, the property that was taken in an unconstitutional fashion. More troublingly, this bill is predicated simply on the belief of third parties. Your neighbor doesn't like you, will now have a mechanism to get the government to take your Second Amendment rights away, to take your firearms away. This bill is about limiting American Second Amendment liberties. Make no mistake, this bill is all just a pretext for the Democrats to take guns away from law-abiding citizens. Think about this. Democrats defund the police, they label parents as terrorists, and now they're going to take away your firearms without due process. This is frightening. I hope we don't pass this legislation. I hope you vote no. With that, I yield back the balance of our time.
The gentleman yields back. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
I thank the chairman. H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, would deprive law-abiding Americans of their due process rights while taking away their Second Amendment rights. It permits a wide array of individuals to petition a federal court to apply for an extreme risk protection order to be issued to take away an individual's firearms when, if there's an issue at all, this should be a state issue and not a federal congressional issue. The person petitioning to take away the Second Amendment right could be a wife, an ex-husband with a grudge, an estranged sibling, a child, a parent, an ex-roommate who may be owed back rent money, or law enforcement. This bill provides a formula that is ripe for abuse of fundamental rights. Issuance of an ex parte extreme risk protection order would permit law enforcement to seize an individual's firearms without the respondent being afforded the right to a hearing. In fact, the firearms can be held by law enforcement for 2 weeks at least before the respondent would be allowed a hearing on the matter. An ex parte order can be granted if the court finds there is probable cause to believe that the respondent poses a risk of imminent personal injury to self or another individual by purchasing, possessing, or receiving a firearm or ammunition. That standard of proof is too low to be depriving law-abiding Americans of their Second Amendment rights. Some states have already enacted similar laws. In Connecticut, for example, nearly a third of all ex parte orders are overturned once a judge hears both sides of the story and considers all the evidence. What other rights are Democrats willing to throw out the window without due process protections? If you value the Constitution and the respect for individual rights and liberties, you should be offended by legislation that proposes to deprive individuals of their right to due process of law before their rights are eliminated and their property seized. This bill, I remind you, is not aimed at criminals, illegal aliens, or fugitives. This bill is trained on law-abiding Americans who are not prohibited by law from purchasing or possessing firearms. They should not lose their Second Amendment right without due process. If your goal is to reduce gun violence, disarming law-abiding Americans without ensuring their due process rights is not the solution. I yield back.
Gentleman,
Mr.
the
Chairman.
gentleman yields back. I want to first say, I see members who are still not wearing masks. I want to put you on notice that you will not be recognized to speak if you do not comply with this rule. If you wish to participate remotely, you are welcome to do so.
Mr. Chairman,
For what purpose does the gentleman seek
ask
recognition?
unanimous consent to enter into the record the memorandum sent from the National School Boards Association last Friday evening to its members where they apologized for the September 29th letter that was the catalyst for the Attorney General's action.
Without objection,
Mr. Chairman, I ask unanimous consent to enter into the record letter from the Ohio School Boards Association announcing it will no longer be a member of the National School Boards Association, quote, as a direct result of the letter sent by the NSBA to the President of the United States last month.
without objection. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2377, offered by Mr. Nadler of New York. Strike.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I now recognize myself to explain the amendment. The amendment in the nature of a substitute makes a number of changes to the underlying bill, many of which are minor and technical in nature, such as adding definitions of certain terms, and some of which are more substantive. For example, it clarifies that no fees would be charged to a petitioner or respondent with respect to an order. It also adds language to ensure that ERPOs are as available to Native American tribes as they are to other communities. The amendment also refines the factors that a court is to consider in deciding whether to issue an ERPO, and it stiffens the penalties for making false claims in petitioning for an order. In addition, the amendment expands the demographic data that is to be collected and reported concerning these orders, and then enhances the training that federal officers must undergo with respect to the use of ERPOs. All of these changes improve an already good bill, and I urge all of my colleagues to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you so much for holding this important markup so that we can take action on saving lives. Nearly 9 years ago, I lost my son Jordan to gun violence. And not a day goes by that I don't think about him. He was just only 17 years old, full of hopes and dreams for the future. Far too many parents know exactly that pain. And like many of them, I turned that pain into action, calling for change so that not another parent would lose their child to gun violence. Across the country, survivors, families, and advocates have demanded that we do more to save American lives. Some states stepped up, passing extreme risk protection orders, or as we call them, red flag laws, that empowered loved ones and law enforcement to take action and keep families safe before it's too late. But as a country, we didn't do enough. We haven't done enough. In 2018, we lost 17 more lives, including 14 more young people at the shooting at Marjorie Stoneman Douglas High School in Parkland, Florida. The world watched in horror as children the same age as my son Jordan, came streaming out of that school with their hands up in the air, terror on their faces. That is when I knew that we had to do more, and I decided to run for Congress. After Parkland, more states took action to save lives of our children and our families. Extreme risk protection orders are now available in 19 states and also the District of Columbia. These laws are life-saving tools to keep firearms out of the hands of those that pose a danger to themselves or to others. They have been passed by state legislatures controlled by Republicans and Democrats and signed into law by governors of both parties. And these laws are truly saving lives. And we American deserves access to this life-saving tool. And that is what my bill provides. Too often we are told that we must accept gun violence. We're told that no single piece of legislation can prevent every incident. And we are also told that instead of changing our laws, we must have more lockdown drills, more security guards, more bulletproof glass, more vigils for those that we have lost. But we also see time and time again that someone knew a shooter was dangerous. Someone knew the shooter had weapons. Someone knew the shooter was filled with violent thoughts, or even that a person was thinking of taking his own life. Too often someone knew, but no one had a tool to do anything about it. The bill that we're marking up today will guarantee nationwide access to this critical tool. With extreme risk laws at the state and federal level, we can prevent gun violence, including mass shootings, suicides, and all the horrific events that do not make our headlines. These events fill our calendars with reminders of those that we have lost, from birthdays that we still observe to celebrate the time that we had together, to memorials for victims lost to acts of hate. Today is one of those all too common days. 3 years ago today, a man entered the Tree of Life Synagogue in Pittsburgh and shouted, "All Jews must die," and opened fire. In the weeks before the shooting, he made anti-Semitic and xenophobic comments online. Just hours before the shooting, he posted an anti-Semitic remark and added, "Screw your optics, I'm going in." He killed 11 people and wounded 6 others, including 4 police officers. It was the deadliest attack on American Jews in the United States history. More than 100 people die each and every day as a result of gun violence. And every single day that we fail to take action, mothers and fathers across this country will live through the same nightmare that I have. Every single day that we fail to take action, siblings and spouses will feel the same agony, the same grief that comes with losing a loved one. More than 100 Americans a day, more than 100 families, 100 communities, 100 people. It is our responsibility to prevent this suffering, to bring an end to this constant heartbreak. Inaction is absolutely unacceptable. Today, we act to help those that are in crisis. We act to empower law enforcement, and we act to prevent the vigil for the loved one that we have lost. I thank my colleagues who have co-sponsored this legislation and the many advocates and survivors who continue to fight to end gun violence in this country every single day. I ask my colleagues on this committee to stand with me in supporting this legislation. Together, we have to save lives. We must save lives. The American public deserves that, and I yield back the balance of my time.
The gentlelady yields back. For what purposes Mr. Shabbat seek recognition?
Move to strike last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. And I would first note, Mr. Chairman, that you already twice made note of the fact that tragically, some members aren't wearing masks. And that may be why some members, more and more, are participating in these hearings and markups in their offices where they don't have to wear masks, rather than in person where they still have to wear masks, despite the fact that many of those members already received the vaccine, 2 shots when Pfizer, if they participated there, and a booster if they're over 65 years of age or otherwise. So I would just note that this is all about posturing. We're not going to give it to each other at this point if we've received the vaccines, et cetera, et cetera. And I just would, I would hope that this committee and the speaker would revise this policy. We do want to be safe. We want to have this virus in the rearview mirror as soon as possible, protect the
Gentleman
public.
yield.
But at this point in
Would the
time, I
gentleman
just
yield?
heard, I'd be happy to yield.
Thank you. I'm not a microbiologist. All I can say is we're following the guidance of the attending physician.
Okay, reclaiming my time, I would suggest that that be revised. And the speaker has allowed herself to be dominant on a whole range of things. For example, keeping the fence up for months and months after it was required, and a whole range of other things as well. But anyway, Mr. Chairman, last week, this committee held a Justice Department oversight hearing in which the Attorney General, Merrick Garland, testified. And I and a number of my Republican colleagues at that time were very critical of the Biden administration and the Justice Department for essentially accusing parents of being domestic terrorists simply because they wanted to be involved in their children's education. The Attorney General's October 4th memorandum, triggered by the National School Board Association, is an example of the left trying to use the full power of federal law enforcement to shut parents up, to chill their protected First Amendment rights by intimidating them. Despite the National School Board Association's apology the following day for sending the misguided, ill-conceived letter in the first place, the Attorney General has not withdrawn his October 4th memorandum. This leads to the conclusion that the Biden administration's Justice Department maintains the position that it will use its federal police powers, which include the Patriot Act and the DOJ's National Security Division, to treat parents exercising their First Amendment rights at school board meetings as domestic terrorists. And this morning, the majority's theme of trampling on the constitutional rights of hardworking American citizens continues. But today, rather than the First Amendment rights, it's the Second Amendment rights that the majority wants to dramatically infringe upon. There's no question that our goal should be to keep guns out of the hands of criminals and out of the hands of individuals with mental illnesses. But this legislation is extremely flawed. It allows a seemingly unending list of individuals to petition a court to remove someone else's firearms merely based upon probable cause, which is a very low legal standard. What makes matters worse is that the individual seeking to have the gun confiscated can do it before giving the gun owner any opportunity to participate in the matter. This legislation clearly decimates due process rights by invalidating significant portions of the Fifth and 14th Amendments. Due process is fundamental to the very existence of our justice system. It's unimaginable that this red flag bill proposes such a low evidentiary standard in an ex parte hearing. It illustrates that the majority really doesn't care about the constitutional rights of American citizens and just wants to take away firearms from law-abiding citizens any way they can. I urge my colleagues on both sides of the aisle to reject this legislation and protect the due process rights of all American citizens to ensure that they can continue to exercise their Second Amendment rights as guaranteed by the United States Constitution. And with that, I yield back, Mr. Chairman.
The gentleman yields back. For our purpose, does the gentleman from Rhode Island, Mrs. Cicilline, seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Chairman Nadler, for bringing this important bill for markup today, and thank you to Congresswoman McBath for introducing this vital legislation. I remain in awe of your courage. It is maddening how frequently we hear that a shooter displayed warning signs of violence prior to a shooting and that no one acted. In the face of so many red flags, can we blame people for asking, why didn't anyone do anything? Unfortunately, the answer too often is because in too many states, there is nothing that can be done, no matter how troubling someone's behavior may be. On average, firearms are used in 64 deaths by suicide per day. 56% of mass shooters from 2009 to 2020 showed warning signs that they posed a risk of violence. The shooter at Marjorie Stoneman Douglas High School showed exactly these kinds of warning signs before he killed 17 high school students and staff. In fact, before the shooting, he'd been the subject of dozens of 911 calls and tips to the FBI, had posted content related to self-harm on social media, and his own mother reported his violent behavior over and over again to law enforcement. But despite all these reports, there was no way to stop him from possessing the automatic weapon that was used to kill 17 innocent people. Simply put, this bill allows a federal judge to temporarily keep a person at extreme risk of committing violence from possessing a firearm. The claims by my colleagues on the other side of the aisle that there's no due process is completely false. This bill sets forth detailed process, requiring notice and hearing, swiftly an opportunity for the individual deprived of the firearm to swiftly contest it, and strikes a balance between the Second Amendment right and the right of the public and other Americans to be free of the ravages of gun violence. People have a right to live in their communities safe and free from gun violence. That is a constitutional right of life, liberty, and the pursuit of happiness. So this notion that we should not have the ability in any way to limit violent and dangerous people who have exhibited tendencies to show they are dangerous themselves or others, that we simply have no choice but to allow them to access firearms and live with the consequences is ridiculous. It's wrong, it's constitutionally unsupportable, and the process in this bill sets forth exactly the right balance. Currently, 19 states in the District of Columbia have similar laws. In my home state of Rhode Island, we adopted such a law in 2018. It has been invoked 76 times between 2018 and 2020 and is known to have prevented multiple suicides. I'm tired of asking when it's too late. Why didn't somebody do something? We have the ability to do something. Today we are doing something, and we would not be here today without the thoughtful, consistent, and deeply committed leadership of Lucy McBath. And I want to thank Congresswoman McBath for this critical, common sense legislation that will save lives and will help us fight the epidemic of preventable gun violence. I'm proud to be a co-sponsor, and I urge my colleagues to support this. And in my final couple of minutes, I just want to suggest to my Republican friends on the other side of the aisle, this hearing is not about the refusal to support the police exhibited by so many Republicans in refusing to support the American Rescue Plan and refusing to address the violence against law enforcement that happened on January 6th and recharacterize it. That's not what it's about. It's not about the efforts to stem violence against educators, teachers, and school administrators and school boards. And it's not even about Attorney General Garland's explicit testimony under oath that, of course, the department recognizes the First Amendment rights of everyone and that parents aren't domestic terrorists, but that the FBI has a responsibility to keep communities safe. And so, despite what will be an ongoing effort to mischaracterize what this hearing is about and to make claims that are unsupported by evidence, this is about a very common sense proposal to protect people from the ravages of gun violence. When people have exhibited dangerous behaviors that indicate by clear and convincing evidence that that person is a danger to themselves or others, if we can't construct a piece of legislation that allows, in those instances, to temporarily remove that firearm with an opportunity for that individual to make their case to the contrary, then we simply are going to say there's nothing we can do. We have to live with the consequences of seriously mentally ill and dangerous people getting firearms, killing themselves, and killing innocent people. That is not a conclusion I'm prepared to accept. And so I end again by urging all of my colleagues to support this excellent piece of legislation. And again, want to say thank you to Congresswoman McBath for her extraordinary leadership, for taking a very painful, unspeakably painful personal experience, the loss of her son, and transforming it into action that will help millions of people be protected from the same kind of tragedy. And I thank you, and I yield back, Mr. Chairman.
For what purpose does Mr. Massey seek recognition?
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, this red flag law that's being marked up today is unconstitutional, it's hurtful, it's redundant, and I'll walk through each of those here in the brief time that I have. First of all, it's unconstitutional. My colleague already conceded that 17 to 19 states have already implemented similar laws. That's because this is the domain of state law. This is not the domain of the federal government. In fact, the Supreme Court struck down the Gun-Free School Zone Act prior because they tried to use it, somebody tried to use it for a gun that hadn't been in interstate commerce. And so this bill already admits to its unconstitutionality because 2 places in the bill, it tries to allude to interstate commerce, and it knows that this has nothing to do with interstate commerce, so the authors of this bill. So it's unconstitutional because it takes the authority of the states, it violates the 9th and 10th Amendments in that regard, in addition to the 2nd Amendment. But more importantly, it violates due process. This is, our country has a rich history of protecting due process, where you are innocent until proven guilty. This bill turns that on its head. You are now guilty until you can prove your innocence. You are deprived of a constitutional right to protect yourself and your family until you can prove your innocence. This is ridiculous and unconstitutional. And here's why it's hurtful. Already, one of my colleagues on the other side of the aisle has said that this will prevent suicides. The problem is it doesn't prevent suicides. People who are having suicidal thoughts will not express those. If this bill they will not tell others that they are having these concerns about harming themselves, because this bill puts them in jeopardy. If they so much as tell a family member or a friend that they are having suicidal thoughts, then they know that their guns will be taken away by the federal government. So there's an incentive now for them to cover this up, to not disclose their thoughts, their hurtful thoughts, maybe to themselves or others. And this goes for police officers too, who know that if they lose their right to own a gun, then they're no longer employable, or security guards. So they're going to hold all that inside. They won't seek help, and you will have more suicides because of this, because this bill is going to presume they're guilty until proven innocent. Now, why is this bill redundant and unnecessary? Because every state in the union, all 50 states, have bills that are sometimes referred to as the Baker Act. In Florida, they call it the Baker Act. This allows the state government to go in and commit somebody to mental health facility, in most cases for up to 72 hours. What's the difference between that legislation that's been implemented at the state level and the legislation being debated today? The difference is that those bills on the books in all 50 states provide help to the person who is supposedly having thoughts of harming themselves or others, whereas this bill provides no help whatsoever. In fact, it goes in and agitates the person who may be having thoughts of harming themselves or others. So the state bills are already there. They're already being used. Again, it's called the Baker Act in Florida, but all 50 states have some form of this. And the difference between that legislation and this legislation is it provides help, but it also involves a mental health professional, which is not, that doesn't come into the equation here. And nobody's getting help from this bill. The money that's going to be wasted on hurting people, the money that's going to be wasted on this bill, wasted on taking away constitutional rights of law-abiding citizens who've done no crime. They're going to be convicted of a thought crime, basically, without a jury or a trial until they can prove they're innocent. That money should be taken and used to provide mental health assistance to the people who we are supposedly concerned about. Yet this bill does none of that. It turns our system of justice on its head by making people guilty until they're proven innocent. And if I may, because it's already been mentioned by 2 of my colleagues already today, we had Attorney General Merrick Garland in our committee last week. I'm still waiting on an answer from him. He refused to answer. He can answer this question. Were agents or assets of the federal government present among the crowd on January 5th and January 6th? If they were they agitating for the protesters to enter the building? And if so, did any of them of those federal agents or assets enter that building? Merrick Garland said he can't answer that question. He absolutely can answer that question. He owes the American people the answer, and I yield back.
The gentleman yields back. For what purposes Ms. Bass seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. It is far past time to pass common sense legislation addressing the public health crisis of gun violence in our country. I'm grateful to my friend, Ms. McBath, for her work on this issue, including on this legislation we're considering here today. I noticed she mentioned the slaughter at the synagogue a few years ago, and I know just a few days before that, there was another shooting of two individuals, two African-American individuals by a white supremacist. And a couple of days after the synagogue, there was another shooting at a yoga studio of somebody who wanted to specifically kill women of color. The simple reality is that extreme risk protection orders help make our communities safer. In my own state of California, researchers found that at least 21 cases where the state's extreme risk law was used to disarm people who threatened mass shootings, including a car dealership employee who threatened to shoot up his workplace and a high school student who threatened to commit a mass shooting at a school assembly. Maybe with this, if this legislation had been enacted, maybe the massacre in El Paso could have been prevented. As of the time that study was published, none of the threats identified were able to be carried out in California. Extreme risk protection orders work, which is why we cannot leave these reforms solely up to the states. We need to give everyone the same tools to prevent gun violence, no matter where they live, as we know all too well that state borders are not barriers to violence. It is essential that we work together to address this issue. That's why I'm proud to support this bill. I look forward to it passing out of committee, and I urge my colleagues to support the bill as well. I yield back.
The gentlelady yields back. For what purposes Mr. Fitzgerald seek recognition?
Thank you, Mr. Chair. Strike the last word.
Gentleman is recognized.
H.R. 2377 is a bill written by the Biden administration and the Attorney General that takes property and gun rights away from law-abiding gun owners without an opportunity to appear in court. This is exactly what happened in EP versus Lakeland Police Department, where an appellate court ruled that the plaintiff's due process rights were violated because the court chose to hear this case virtually instead of in the court facility listed in that order. Red flag laws violate Second Amendment rights without due process. Just to make the point that this is a state's issue, when I was in the Wisconsin State Senate, I was part of a charge against red flag laws proposed by Governor Tony Evers, and we adjourned the governor's special session on that issue. We cannot sacrifice our constitutional rights. H.R. 2377 is egregious in its due process violations against law-abiding gun owners, and I will oppose it. I urge my colleagues to vote no on H.R. 2377, and I yield back.
The gentleman yields back. For what purposes Ms. Jackson-Lee seek recognition?
Strike the last word, Mr. Chairman.
The gentlelady is recognized.
Mr. Chairman, I could not be more proud of this body, this committee, and more proud of Congresswoman McBath. As the chair of the Subcommittee on Crime, Terrorism, and Homeland Security, I'm particularly proud of all of our members' commitment to just laws. And the law before us, the bill before us, is no less just. The only thing I see in the work of Congresswoman McBath is that she has sought justice. Justice for victims, justice for families who beg to have a way to deal with individuals who they love and care for, but they know provide an extreme risk. Violation of the Constitution? I'd like to see that clarified. This in no way undermines the Second Amendment. Frankly, if one reads literally the Second Amendment, it is a stand-up and a militia. Subsequent interpretation has made it a singular standard of godlike behavior. So I rise with great enthusiasm for this work. With this committee's consideration of H.R. 2377, the Federal Extreme Risk Protection Order Act, we are responding to our citizens across the country who've been urging the enactment of gun violence prevention legislation, but particularly families who cry out, "Help me, help my loved one." In recent years, we've mourned the loss of life resulting from so many mass shootings that have shocked our nation. But we must recognize and acknowledge that gun violence is a daily problem that extends far beyond these terrible mass casualty murders. Every day, 316 people on average are shot in the United States, and over 38,000 people die each year from gun violence in this country. And every year, nearly 8,000 children and teens are shot in the United States. School shootings have become a pandemic and an epidemic. Each shooting is a tragedy with devastating impacts on individuals, families, and communities, and the problem of gun violence does impact all of our communities, urban, suburban, and rural. We must do all we can to prevent each of these tragedies, and there is more we can do. Expanding the availability of extreme risk protection orders is one important step we must take. General Garland willingly acknowledged the importance of these laws. He is the Attorney General for all of the United States, and they have shown that as the Department of Justice has worked for all rights of all Americans. 19 states and the District of Columbia have passed extreme risk protection laws, which are proven to be effective. In California, one study found that extreme risk protection orders were issued under that state's law in 21 instances where there were concern of a mass casualty event. After Connecticut enacted an extreme risk protection order law, the state experienced 14% reduction in its firearm suicide rate. That is crucial. People killing themselves, families needing help. In Indiana, the number of suicides declined 7.5% in 10 years after it enacted its extreme risk protection order. While some states have enacted these laws, many have not. But all of our citizens deserve to be safe from gun violence, no matter their state of residence. That is what the responsibility of the federal government is, and that is what, under Chairman Nadler, the responsibility of the Judiciary Committee is, to bring justice to all. And that is why we need a national law, which is what H.R. 2377 will provide. When family or household members or law enforcement officers can demonstrate evidence that an individual presents a serious threat to themselves or others by use of a firearm, they should have the opportunity to seek an extreme risk protection order before our federal courts, allowing a judge. This is not snatching away your constitutional rights, rights of privacy and beyond, due process, however you would analyze it, allowing a judge to weigh the evidence and issue an order when appropriate. I was here for the tragedy of Connecticut. And so I commend Representative Lucy McBath for her work on this bill and on the other issues related to gun violence. I ask my colleagues to support this important legislation and to make us safer from firearm violence, whether it's in our homes or on our streets. It is our duty to do so. For all of those who believe in law enforcement, who recognize the most recent important day in our law enforcement community, honoring those who fell in duty, in the line of duty. If you care about those individuals, you will support this legislation. If you care about 26 children murdered and slaughtered in Connecticut in an elementary school, where the individual who, in fact, came and not only killed them, but killed himself, you would understand the basis of these and this law. You would understand that it is now imperative that we pass the Federal Extreme Risk Protection Order Act, and I'm very proud to support it at this time. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purposes does Mr. McClintock seek recognition?
To speak on the amendment.
The gentleman is recognized.
Thank you, Mr. Chairman. This is what I don't understand. Yes, there are people, particularly those in a mental health crisis, who pose a danger to themselves or to others. That's very clear. And that danger is not just limited to firearms. I mean, there are plenty of examples of attacks by such people with knives, axes, machetes, baseball bats, strangulation. Suicide's not limited to firearms, jumping off a bridge or out a third.
The gentleman yield for a moment?
Yeah.
I would just observe, as a matter of experience, that an attack with a firearm is much more likely to be lethal than an attack
Oh,
by
no, there's no
baseball bat
question, no
or
question about
knife or
that.
whatever else.
But the point is, there are many, many cases of attacks by people in a mental health crisis that don't involve a firearm, but are just as lethal and just as deadly to the victims. The point is that if the person poses a danger to themselves or to others, they need help. And simply removing firearms from the occasion is not getting them that help. The fact is, every state in this country has commitment procedures to do that. And those commitment procedures respect a person's due process rights. They take expert testimony of trained psychiatrists. They respect the due process rights of the accused. That's the appropriate course to take when we identify someone who may pose a danger to themselves or to others. We're said this doesn't trample on rights, this respects due process. Well, due process includes the right to contest charges, the right to face your accuser, the right to present evidence on your own behalf, the right to cross-examine witnesses. This measure allows for none of these rights. This measure allows the government to seize firearms, which are protected by the Second Amendment to the Constitution, with none of these rights. The seizure's done without the accused even knowing that the process has taken place. Only in retrospect can they then contest the confiscation. This is the brave new system of justice that I'm afraid the left would impose on us. Sentence first, verdict second. Either a person's a danger to themselves and to others, and we should get them the help they need, respecting their due process rights, as we do in every commitment proceeding that takes place in all of the 50 states, or they don't pose a danger to themselves or others, and the government has no place denying them their constitutional rights. I yield back.
The gentleman yields back. For what purpose does Ms. Escobar seek recognition?
Move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, on June 27, 2019, at 11:15 in the morning, a worried mother called the Allen, Texas Police Department. She shared with them her concern about her son, who owned an AK-47. She was worried about her son owning this weapon of war because of his age, maturity level, and lack of experience handling the weapon. His mother was transferred to someone at the department whose response was that her son was legally allowed to purchase the gun. Weeks later, on August 3rd, that young man drove 10 hours to my community of El Paso, Texas. On a sunny Saturday morning, he walked into a Walmart, one of the busiest in town, while families were shopping for groceries and school supplies, and he began what would be the deadliest targeted attack against Latinos in modern American history. He confessed to wanting to slaughter Mexicans and immigrants, and he used anti-immigrant rhetoric used by some of my colleagues on this very committee, calling our presence in the United States an invasion. 23 innocent lives were taken, dozens were injured, and my community was and still is devastated. Mr. Chairman, I seek unanimous consent to enter into the record the ABC News article, "Mother of Alleged El Paso Shooter Called Police About Son Owning Assault Rifle."
Without objection.
Mr. Chairman, Ms. McBath, thank you for your leadership on this issue, and thank you for bringing this bill forward to our committee. To my colleagues, when we talk about rights, I ask you, what about the rights of my constituents to live free from fear of being massacred? And for those who want us to punt to the states, I can tell you that we cannot depend on state government to protect the health, safety, and welfare of our constituents. And example number one is my own state of Texas. After the massacre, Governor Greg Abbott came to my community, came to El Paso, and he promised he would act on gun violence prevention. He gave my community his word. His word turned out to be worthless. Even after the massacre, after that empty promise, Texas now has some of the loosest gun laws on the books in the country. So no, the state cannot be trusted as long as there are elected officials willing to trade the lives of their constituents in exchange for NRA money and votes. So it's up to us to ensure our communities are safe. And I'm proud to support this common sense legislation. Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. For what purpose does Mr. Tiffany seek recognition?
To speak on the bill, Mr. Chairman.
Gentleman is recognized.
Thank you very much. So we heard in the chairman's opening remarks, he said, only 14 days. That was the quote. And so only 14 days to give up your rights. It's reminiscent of about 18 months ago when it was 2 weeks to stop the spread. Is this the standard we use now, that it's only 2 weeks that you give up your rights? We all know if you give them up, you give your freedoms up for a day, it may be a lifetime. So one of the things that's being left unsaid, there's a fair amount of talk here today in regards to the school shootings, which are really horrific actions that have been taken. But in one of the South Florida shootings, the FBI was notified. They ignored the actions that they ignored what was happening and the actions they could have taken. An FBI that seems to have lost its mission here in America. They should have been paying attention to things like this where it truly has to do with the safety of the American people. The other thing I would say is we have a statute in Wisconsin, it's called Chapter 51, and my colleague from Wisconsin alluded to it earlier, which handles involuntary commitment. The state of Wisconsin is handling this just fine. And what I would say to the federal government in regards to an issue like this is, butt out. This is used rarely, but it's used appropriately in Wisconsin. And it was written in a way that was constitutional in our state. So I just say to the American people out there, you're seeing a pattern in this Congress in the short 10 months that it's been here. And I sure hope the American people are paying attention. We have a couple bills before us right now that are being negotiated. Trillions and trillions of dollars are going to be spent. What's one of the key provisions in it? 87,000 new IRS agents. Boy, doesn't that make you feel good. $10,000 in transactions. Oh, it went up from $600 to $10,000. Don't worry, we have compromised. $10,000 in aggregate transactions in a year. There are very few people that will not meet that threshold. We have an attorney general last week that wanted to deny people their First Amendment rights. And I would say to my colleague on the other side of the aisle, then why did he write that memo saying that the FBI should work with local law enforcement? Why did he write that memo then, if he didn't really mean to put the jackboot of the federal government on parents who simply attend those local school board meetings? By the way, I'm one of those parents who has attended school board meetings over the last 18 months with my friends, my neighbors, and with my constituents. And as a former town board member who was in a few ruckus meetings here and there, there's an easy way to deal with it if people get out of control, is you call your local sheriff department. Federal government, butt out. The states can handle these situations. And by the way, while talking about the actions of the Attorney General, where he contemplated, let's put the full weight of the government, the FBI, the Department of Homeland Security, even the Security Division of the Post Office. Did you all know there's a Security Division of the Post Office? The school boards asked for all of it, and the Attorney General was willing to grant that for them. And I would point out, an August member of this committee who is no longer here, whose picture is hanging on the wall right over there, wrote a lengthy article about using the Patriot Act against parents in America. That was never contemplated. I urge you to read that article if you doubt at all what could happen if the Attorney General gets his way with parents across America. Let's be real clear. Federal extreme risk protection orders are a fancy name for red flag laws, and they are a very simple thing that the left has been trying to do in this country for decades, and they will continue to do it, and that is simply a gun grab. This bill is written for gun grabbers across America. We must vote no to protect Americans' fundamental freedoms, whether it's the First Amendment, the Second Amendment, or all of them that have been written to protect us all. Thank you. I yield back.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. I'm so proud to support Congresswoman McBath's bill, the Federal Extreme Risk Protection Order Act. I'm also proud to align myself with parents, family members, mental and public health experts, law enforcement, in seeking this common sense gun safety measure. You know, about 2/3 of all gun deaths annually are suicides. In Pennsylvania, gun suicides, I'm sorry. In Pennsylvania, that's about 1,000 people we lose every year to gun suicide. 17 veterans die by suicide each day, and in Pennsylvania, 70% of those veterans who commit suicide use a firearm. In the states that have enacted extreme risk protection order laws, those measures have proven to be an effective tool in preventing firearm suicides. And studies have shown that a large number of people subject to these acts actually seek and receive mental health treatment as a result of these interventions when they may not have otherwise. We've heard from some of our colleagues' stories of folks who are not seeking to kill themselves, but to kill others. We have to take action. The situation as it stands now is not tenable. I have to reject the crazy mischaracterizations we're hearing across the aisle of these acts being unconstitutional. Challenges to extreme risk protection acts generally are not succeeding, and this bill has been carefully crafted to comply with the Constitution. I also am shocked at the idea that one would substitute deprivation of individual liberty to commit people to mental health institutions, as has been suggested, as some kind of preferable alternative to the short-term removal of dangerous weapons from someone who is at risk to themselves. And as for this idea that there's no due process consideration here, that's also a fiction. There are multiple levels of due process available here to someone who is adjudged, first of all, upon sworn testimony by a judge to that there's probable cause that such a person might be a risk to themselves or others because of the guns they possess. And then there is opportunity for that person to challenge that judgment. I mean, there's multiple levels here. There's high standards. I think it's a carefully crafted bill, and we need to move forward. In the past 4 or 5 years, we've seen 40% of our states and the District of Columbia pass some version of extreme risk protection acts. That's not enough. In Pennsylvania, we've had both Republican and Democratic legislators propose such legislation, but the number of our legislators who are still enthralled to the NRA and refuse to even pass constitutional, common sense gun safety measures is still so strong. So if the states are not going to act to protect our citizens, then Congress must do so. At a time when mental health issues are on the rise, it's more important than ever to create a federal extreme risk protection order law. We need to ensure that people nationwide have access to this life-saving measure to help those in their lives who may be threatening harm against themselves and others. We have to give people an avenue that if they see something, they can say something and have it be heeded, unlike what we saw in the Parkland shooting, unlike what we saw in El Paso. In so many cases, suicide or a mass shooting is preventable, and this bill provides short-term protection to those in crisis so they can get the support they need and keep themselves, their loved ones, and their communities safe. I urge all of my colleagues to support the bill, and I look forward to passing it out of committee today and moving it to the House floor as quickly as possible. I yield back.
Gentlelady yields back. For what purpose does Mr. Issa seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, Let me start by asking unanimous consent that the syllabus or the extract of the Supreme Court decision of District of Columbia et al. Versus Heller be placed in the record.
Without objection?
Mr. Chairman, earlier one of our senior members made the constant and pervasive statement, one that I want to make sure does not be allowed to stand in the record, that the Second Amendment is about militias. In the Heller decision, decided in June 26, 2008, when both the chairman and that member were here, it was made clear that, as I'll quote, number one, the Second Amendment protects an individual right to possess a firearm unconnected with the service in a militia. I don't think you can be any more unambiguous than that, and I hope that this is the last time that I have to hear somebody constantly saying that our Second Amendment right is a right of the National Guard or something of the sort.
Would the gentleman yield for question?
Of course, Mr. Chairman.
Thank you, but isn't it also true that in the Heller decision, Justice Scalia said that reasonable firearms regulations were constitutional?
Mr. Chairman, you're absolutely right. This one is not a reasonable firearm legislation. One of the reasons that what we're considering with 2377 today is not reasonable is that it does not even begin to pass the, if I would call, the proper and appropriate test. Mr. Chairman, in one of your opening statements today, at a sidebar actually, you made the case when you said you were not a microbiologist. Mr. Chairman, a federal judge is not.
That is certainly true.
It remains true, as does it for me. But Mr. Chairman, a federal judge or a magistrate, more likely, is in fact not a psychiatrist or a medical doctor. The lack of a due process is paramount, and if you're going to somehow preempt due process, you certainly need to find an appropriate skilled professional. An estranged family member, an angry neighbor, or just a political enemy is in fact not an expert, nor is a federal judge. So we start off with that defect even before we get to the other defects of this bill. Certainly 14 days is an awful long time to be denied your Second Amendment rights. I will close my statement and say that for the author of the bill, some years ago, about the time the Heller decision, my nephew was here working for Congressman Kucinich. He worked for about 4 months for him and thoroughly enjoyed it. He was a college graduate trying to figure out when and where to go to law school. A few months later, he killed himself by hanging. He had problems that had been diagnosed. He had been under medical care on multiple occasions. Suicide is a terrible tragedy in America, and it is one that we must take seriously. It is also one that is not easily prevented. The tools available for someone to take their own life, unfortunately, do include jumping off a bridge, hanging oneself, an overdose of any number of drugs, or worse. So although they're constantly talking about either suicide or homicide, let us understand that mental illness and the need to do it, which is not primarily the committee's jurisdiction, certainly needs to be taken seriously. And in this case, among the many defects in this bill, the lack of any consultation with somebody who could make a qualified decision as to the individual, even if this bill reached out and said an EMT has seen this person, a police officer who has supplemental training, anything that would allow for that skilled decision for a short period of time could potentially, at least at a state level, reduce the harm that this bill might do. But in the absence of that, I cannot support it and will not support it. I will close with this. I do not stand with the NRA. the NRA stands with all of us who believe that the Second Amendment is a critical element that has served us well for 240 years in protecting all of our rights. And I yield back.
Gentleman yields back. For what purposes Mr. Cohen seek recognition?
Thank you, Mr. Chairman.
You move to strike the last word?
Yes, sir.
Thank you. The gentleman is recognized.
I want to commend Congressman McBath and the other members who've worked on this bill. There are two options on this bill. One option is to vote for it, pass it, save some lives. The other is to offer thoughts and prayers. We've had enough thoughts and prayers. We continue to have thousands of victims of gun violence, people killed. Suicides, yes, but homicides. In Memphis, we've had quite a few lately. Man went into the grocery store, killed one person, shot a dozen others. Student went in elementary school or junior high school, student, like 8th grader, went into school and shot another student. 3 students outside of high school were shot just yesterday by another. If there is probable cause, which is a fairly, it's not the highest burden by far, but it's a burden that has to be met, and it means there's a probable cause, means a pretty good thought that somebody's going to do something, that somebody is going to commit an act of violence, homicide, suicide, whatever, against somebody else. And a judge, federal judge, not a justice of the peace, but a federal judge who is not a gun grabber, finds that probable cause exists, that this person's going to do harm, and has the weapons ordered to be taken with the person having a right to come in within 72 hours and have a hearing and show the reason why they are not what was alleged, due process is involved, then that should occur. If there are issues or concerns, I would submit just a baseball, the tie goes to the runner. In these type of situations, the tie should go to person that would otherwise be the victim. You can't bring a life back. When they're gone, they're gone. Show me a case, please. We didn't have them in Memphis, where a good man or woman with a gun protected and stopped the use of a weapon. That canard doesn't occur. That just dog won't hunt. It doesn't happen. And show me a case, we've talked about people losing their Second Amendment rights through these procedures. Show me a case anywhere, in any of those 16 states or anywhere, where somebody had their guns taken and then they were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them. I don't think you'll show me any, and if any, not many, cases where anybody, because they didn't have their Second Amendment rights gun with them, were a victim because of a red flag taking of their weapons, temporary taking. These are people on the cusp of committing a violent act against a person, themselves, or an animal for that matter. And those entities are being protected. We need to protect people. We need to protect people, not just give them thoughts and prayers. One of my colleagues and friends said something about being without your Second Amendment rights for 2 weeks. Go to your psychiatrist and let him tell you what Freud said about that. You can deal with it for 2 weeks. This is a good bill. It'll protect and save lives. There are not cases that you can show that indicate that these laws in the 16 states in the District of Columbia where they exist have caused people to lose their lives because they didn't have those weapons. there are situations where it can be shown that it protected somebody's life and health and/or a pet's life or an animal's. So I'm proud to support this bill. I think we all should. Time is over for thoughts and prayers. It's over for just lining up and being for the NRA. And the NRA, they went bankrupt last year, spending a lot of money on their executives, a lot of money on themselves. They like to sell bullets and guns, and that's what they're there for. I yield back the balance of my time.
The gentleman yields back. For what purpose does Ms. Fishbach seek recognition?
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
Mr. Chair, this bill undermines Americans' fundamental rights and contradicts the foundational pillars of our justice system. It appears to be a step toward universal gun registration, which is a violation of Americans' right to privacy. Without a federal gun registration database, how will officers know whether the respondent owns any firearms to begin with, or how many firearms are supposed to be confiscated? This bill could turn law-abiding gun owners into criminals without a crime ever being committed. What will happen to a law-abiding gun owner who has committed no crime if they refuse to hand over the firearms without due process? Let's be honest about what this bill really is. It's an attempt by my Democratic colleagues to use the federal government to intimidate gun owners, the same way they are using the federal Justice Department to intimidate school parents. Police departments around the country are already stretched thin. Officers have been leaving in droves as calls to defund departments and demonize the profession continue from some Democrats. As Democrat-run cities continue to tie the hands of police officers and cut their funding, we have witnessed crime rates go up and arrest rates go down. In Minnesota, for instance, the clearance rate for human trafficking crimes were down from 72% clearance rate in 2019 to only 18% in 2020. Nearly every type of crime saw a decrease in clearance rates in the last year. Not because our brave police officers are not doing their job, but because they are not being given the tools they need. Instead of helping police enforce our laws, Democrats want to use our police to enforce their political agenda. Mr. Chair, I oppose this bill adamantly, and I appreciate the opportunity. Mr. Chair, I yield back.
The gentlelady yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. San Jose, Boulder, Atlanta, these are only some of the high-profile mass shootings from this year alone. In San Jose, we lost 10 people. In Boulder, another 10 lives were lost. In Atlanta, the lives of 8 people, including 6 Asian American women, in one day, taken by gun violence. These are just a mere fraction of the mass shootings from this year. The dozens of mass shootings this year alone underscores the relentlessness of this epidemic. The problem is that we have normalized these incidents. We now anticipate the next one. Congress must do more. We must do more to stop this. Here are the tragic numbers in this country. At least 39,000 people a year, 100 people every single day, die of gun violence. 23,000 of those die by gun suicide. Gun access triples suicide risk. And this shameful global distinction, Americans are 25 times more likely to be killed by a gun than in any other high-income country. Domestic violence victims are 5 times more likely to be killed by their abuser if there is a gun in the house. So you can imagine I proudly lend my support to Representative McBath's federal extreme risk protection order. And I thank her for her courage, her thoughtfulness, and her wise crafting of this legislation. Although red flag laws already exist in 19 states and in Washington, D.C., that's not enough. Gun violence is a national epidemic that requires a national response. When people are in crisis and pose a threat to themselves or others, Those closest to them are the first to notice and see the warning signs. Extreme risk laws allow for people and law enforcement officers to respond with immediate action. These laws allow family members or law enforcement to petition for a court order to temporarily bar people in crisis from accessing firearms. As members of Congress, we have a duty to reduce all forms of gun violence: community violence, mass shootings, domestic violence, and suicide by firearm. This law is a powerful step in the right direction toward addressing this epidemic, and it is an epidemic. And yet, I can see that those on the other side of the aisle who are still quibbling over masks don't even recognize the threat of a pandemic, where we have lost, over the course of these last almost 2 years, on average 1,000 people a day, and still quibbling over masks. I feel very differently. I feel we have a responsibility to protect life, whether it is from a pandemic or an epidemic like the scourge of gun violence in this country. I thank my colleague and friend from Georgia for being such a champion, and I ask my colleagues to support this. I yield back.
Gentlelady yields back. For what purpose does Mr. Gohmert seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you. I was struck by a friend from Tennessee's words that basically we can pass this bill or we can provide thoughts and prayers. John Adams said, this Constitution was intended for a moral and religious people. It is wholly inadequate for the government of any other. This nation has always provided individuals with access to guns, but this nation has not always had so many mass shootings. What's the difference? Well, I would submit that when you go back to the 60s and the movement to teach children in school that there is no moral right or wrong, there is no right or wrong. It's just what you feel, what you concoct in your own young head without guidance from a responsible adult. That's what is right. Whatever you think, don't tell a child no. The difference is we've gone for decades now allowing less and less teaching about moral right and wrong. There's a great deal of confusion. This nation does have a choice. Because just as John Adams said, if we're not going to go back to teaching that there is moral right and wrong, then we will need to get rid of the Second Amendment, not this mamby-pamby cutting off the Second Amendment around the edges, but you'll just have to eliminate it because nobody understands that it's not a good idea to shoot people just because you feel bad or you think it might feel good, so just do it. The choice is getting back to teaching a moral right and wrong, or we can continue to mock Americans who pray before they act and seek God's guidance. Some pray for wisdom. I've been praying for wisdom since I was 6. I believe the Hebrew Bible that says God will grant wisdom as you ask. The problem is he doesn't say when, so it's obviously more than 50 years after you start asking, sometimes before it's granted. But there is wisdom in seeking wisdom before acting. That Hebrew Bible I believe in says the wisest man that ever lived was made wise because he asked for wisdom. Perhaps there's wisdom in not mocking those who believe in prayer, mocking, belittling, stirring up sentiment against those who believe in and seek the wisdom and assistance of God could someday even lead to shutting down churches in a time of national emergency. Oh yeah, we just did that. But it could also lead to discrimination and even violence against those who seek God and pray. But we've already been having that. So we can continue to eliminate prayer and continue to belittle those who pray and seek wisdom before they act. Or we can eliminate the rights that we currently hold dear, not just second. You're going to have to eliminate freedom of speech. Oh yeah, we've already been doing that. But we can be eliminating freedom of assembly. Oh yeah, we've been doing that. Okay, well, we can continue to eliminate the rights the Constitution has given us, or we can get back to having parents care more about what's taught in school and making sure children in school are taught there is a moral right and wrong, and not moral relevance or equivalence of whatever suits the young mind that we're supposed to be training. This is a critical issue that goes to the heart of this very country's existence. Let's get wisdom before we start striking down our rights. I yield back.
The gentleman yields back. For what purpose does Mr. Raskin seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Well, I was moved by the gentleman's critique of moral and factual and scientific relativism, which struck me as a great description of the conversation we're having in America right now about the 2020 presidential election, which Joe Biden won by more than 7 million votes, 306 to 232 in the Electoral College. And still, we have a former president of the United States and a large part of his party, which continued to deny that and claim that he won the election. So I can't think of a better example of precisely the syndrome he's talking about, of people denying the existence of an objective reality. But Mr. Chairman, I want to thank the gentlelady from Georgia for introducing this superb legislation. And if she would yield for a question, I just want to ask her this, because I know that there are 19 states, including my state, Maryland, and the District of Columbia, that have adopted red flag laws. And I want to know whether they actually do work to save lives. Do we actually have warning in some cases that a person might be prepared to carry out a violent gun attack on other people, either a mass attack or to harm themselves or to harm other people?
Well, thank you so much, Representative Raskin, for those questions. And, you know, to my knowledge, the 19 states that have enacted red flag laws, no, there have not been any that have been struck down simply because they recognize that the number of homicides and also suicides continue to drop. They decrease because, you know, the safety measures that are being put in place. And actually, we know that in 80%, about nearly 80% of the perpetrators that are actually creating kinds of statements, making statements, are acting with very dangerous behaviors. They're actually kind of letting people know in advance, their families, their loved ones. They're letting people know in advance their intentions to do harm in these mass tragedies. So,
well, I thank the gentlelady very much for both of those points. One point being that in a majority of the cases where someone's going to carry out a mass attack, like the Tree of Life cinema, the Tree of Life synagogue attacks, the attacks in Charleston, South Carolina, El Paso, Newtown, Connecticut, these massacres, there are reasons to believe they've either told people or there are reasons to believe that they will act. And so the red flag laws help to empower family members and other intimate people to come forward to say, we've got a real problem, we've got a danger, and it's working. But you've also pointed out, Ms. McBath, and I appreciate this very much, that with all of the very loose talk about the Second Amendment here, not a single one of these statutes has been struck down. despite the fact that lots of them have been brought to court. And why is that? It's for the reason that the chairman indicated before. And it is precisely the Heller decision, which did reject the militia-based concept of the Second Amendment, said that individuals have a right to weapons for the purposes of self-defense and for purposes of recreation. But of course, said Justice Scalia, they are subject to all kinds of reasonable regulation, the same way that the First Amendment is too. I mean, there are reasonable time, place, manner restrictions for the First Amendment. You can protest outside of the White House, but not at 2:30 in the morning with a loud sound system that's going to make it impossible for people to sleep. That doesn't violate the First Amendment. That's not a regulation that violates the First Amendment. It's consistent with the First Amendment. And these laws have been found to be perfectly consistent with the Second Amendment. So we should stop confusing the public about that. Mr. Ice's point was that the judges are not doctors or psychiatrists, but the statute doesn't refer to mental illness. It doesn't require the diagnosis of a specific mental illness. It simply references the standard of whether a person poses a risk, an imminent risk to themselves or to other people. That's precisely the same standard that governs in the involuntary commitment civil statutes, which our colleagues in the minority are praising with respect to taking people to court and then to involuntary commitment. By the way, those statutes are still very much part of the law, so it's not an either or. If people can be involuntary committed for inspection and interview and diagnosis for several days, certainly we have the much lesser right to take away their guns so they don't hurt themselves or other people in the meantime. This is excellent legislation. I want to thank Ms. McBath again for her leadership for this common sense, perfectly constitutional legislation, which has been adopted with great success around the country. I yield back, Mr. Chairman.
Thank you, Mr. Raskin. The gentleman having yield back. Mr. Bishop, for what purpose do you seek recognition?
Move to strike the last word, Mr. Chairman.
So granted, 5 minutes.
I wonder whether Mr. Raskin would yield to a series of questions.
By all means.
Thank you, Mr. Raskin. Just in reviewing the law and just sort of to take little of the heat and just discuss exactly what we have before us, I wanted to ask you if my reading of it is right in several respects, and a couple of questions that come from that. You're a constitutional law expert, as I understand. First of all, as I read it, the petition provision on page 4 says that essentially any family member or state or local law enforcement officer anywhere in the country can go to federal court to seek this kind of order. Isn't that right?
But anyone who has knowledge of the relevant facts of the person posing an imminent danger to himself or to others. Yes.
Yeah, and anywhere in the country. And of course, a lot of state courts that deal with domestic violence and all these things. So this would open up the federal courts to that. My understanding is the federal court system is has limited jurisdiction under the Constitution. It's limited to cases arising under federal law or disputes between citizens of different states, basically. I mean, there are a couple of things we could get into, but that's basically right, isn't it, Professor?
Yeah, you need to have federal jurisdiction.
Okay.
And the law would create the federal jurisdiction.
So this law, which confers jurisdiction on the federal court, would also be the federal law under which it arises for federal jurisdiction purposes?
Well, this is how all federal laws work.
Usually you have a substantive law created, and then separately Congress confers jurisdiction on federal courts, right?
Well, usually there's a jurisdictional component in the federal statute itself, establishing federal jurisdiction.
All right, so the way federal jurisdiction is founded here, if I understand correctly, is this language on page 12 about interstate commerce, and it says, and that's where it says, the court shall order the respondent to surrender all firearms and ammunition that the respondent possesses or owns in or affecting interstate commerce. That's what I think someone referred to it in their questioning earlier. I guess my question for you, Mr. Raskin, as I read it is, how does the mere ownership or possession of a gun, how can that be in or affecting interstate commerce?
Well, as I understand it, what we've done with all federal firearms regulations since the Lopez decision is to create that language that you just referenced. In other words, the statute says that the guns must relate to interstate commerce.
I'm asking a much more basic factual question. You might ask me if I were in your law school class, and that's to say, if I possess a gun or I own it and nothing else appearing, how does that affect, or how is that in interstate commerce? And the interstate commerce is commercial activity between states, isn't it? Or involving the pattern of interstate, of business between states, among states?
Well, my understanding of this legislation is that it tracks the federal constitutional standard established in the Lopez decision,
Okay,
which said,
it must be a more complicated answer that can just be given factually. So let me just move on to something else then. As I was looking at pages 7 through 9, this is not only about a temporary deprivation for a few days or something like that. The court can enter an order, a long-term order for 180 days, and it looks like on pages 10 to 11, the court can renew the 180-day orders forever, potentially, without ever subjecting any of this to a jury or requiring any conviction of any wrong. Is that correct?
with notice and opportunity to be heard, and a judge deciding on a probable cause standard that the person presents an imminent risk of injury to himself or to others.
Wow. So he doesn't get it, but he doesn't get a jury trial, and he doesn't ever have to be convicted of a crime, or she, and can lose their rights potentially indefinitely and potentially permanently by virtue of the extension of these orders every 180 days, right?
Well, that's right, because no one's being put in jail and no one's being convicted of a crime.
And that's
remember, this is
justifiable.
A prophylactic civil standard. It's a protective regulatory statute.
Let me ask one last thing as long as we're talking. In the last hearing with Attorney General present, and this was also something we were concerned about, people's rights, you said that Donald Trump, quote, has given license to the darkest impulses in right-wing politics and given rise to conspiracy theory-driven mob violence, not just at state capitals like we saw in Lansing, Michigan, which was a dress rehearsal for the January 6th attack, but also it's in schools and school boards across the country. The School Boards Association has apologized to parents across the country for attributing to them the characteristics of domestic terrorists. Do you want to retract that comment, Mr. Raskin?
Retract what? There are lots of cases of people threatening school board members and teachers taking place across the country. I mean, are you denying that?
Yeah, I am. I yield back. I'm out of time.
All right.
The gentleman yields back. For what purpose does Ms. Garcia seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, it's been really interesting sitting here now for almost a couple of hours listening to some of the remarks being made, particularly from across the aisle. To hear statements like, this is just ridiculous and it's on its face unconstitutional, is, to me, what's ridiculous. It's the comments that I keep hearing, because this is really a very simple bill that, quite frankly, we passed this last time. This was not some scheme that the President and the Attorney General, as has been again alleged by members of the other side, to take guns away from people. I mean, this bill actually was looked at last time. I supported it last time. I support it again. I thank my dear friend and colleague, Lucy McBeth from Georgia, for bringing it to us again, and congratulate her with her passion and commitment on this issue. And I'm here to strongly support this bill. These arguments about due process, I mean, I'm a former judge. I kind of know a little bit about due process, and basically it's an opportunity to be heard. The person will have an opportunity to be heard. They will have an opportunity before a judge before it's final. So I don't understand some of these arguments. Due process is a word that gets thrown around a lot, but if you read the bill, the due process protections are in there. This is not any unilateral action, and frankly, it's not a bounty scheme. This whole idea that, well, anybody in the country can file on this. No, it's not. It's very different than the bounty scheme of the abortion law in Texas, where anybody in the country can file it. I mean, we've already had one case of someone in jail in Arkansas file one of those cases. This is someone who has to witness and see the behavior and pattern of the danger that someone could have to themselves or others. They have to attest to being able to say that they saw this and they fear that this person actions may lead to violence and to further harm to himself, herself, or the community. And I think it's important to note that the last poll that I saw, 77% of the people in America support the red flag laws. And this whole idea that, well, it's a states thing, let me tell you something. Not only am I a former judge, I'm also a former state senator from Texas. And I can tell you that we can't pass a red flag law in Texas. And in Texas, when I was there, and we argued a red flag law on the floor, and I debated a red flag law on the floor of the Texas Senate, we were argued against and saying, well, you know, the Congress should do something about this because this is about all the states. We shouldn't just do something here in Texas. So, you know, I think you got to be careful what you ask for and what you allege. And finally, let me say this. You know, I'm a native Texan, and like a lot of native Texans, I have a gun. I still have a gun. But I grew up on a farm, and my family taught me how to use it. They taught me how to respect it. And mine was never a handgun or an automatic weapon that shoots people. Mine was always a .22 rifle or a .410 shotgun. And that was meant for hunting. And yes, I've gone hunting many times. And it was meant to put food on the table because we were poor. If we went out there and didn't hunt and kill something, then we ain't gonna eat that night. So that's how I learned about guns. It was for sometimes sport, but a lot of times about putting food on the table. It was never meant to be, my dear friend, Ms. Macbeth, to kill people, to shoot people. In fact, I don't know how to use a handgun. I'm a terrible shot with a handgun. But I'm pretty good with a .22 rifle. Close to being an Annie Oakley, I would even say. But you gotta have parameters. This is not about taking guns away from people. This is about taking guns and keeping them out of the hands of the wrong people. So with that, Mr. Chairman, I do want to introduce an article from NPR entitled "Americans, Including Republicans and Gun Owners, Proudly Support Red Flag Laws." And as a gun owner, native Texan, I too support a red flag law. With that, Mr. Chairman, I yield back.
Without objection, and the gentlelady yields back. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
The gentleman is recognized.
Well, as the gentlelady on the other side of the aisle knows, I too live in Texas. Raised my son, daughter to respect firearms. We shoot them frequently on our property. We shoot semi-automatic weapons on my property. I teach my children how to use them safely. I teach them what they're used for, why we have the ability to have firearms. And yes, we use it for hunting. My son shot his first deer.
Would the gentleman yield for a question?
Briefly.
Yeah, very question. What do you use semi-automatic weapons for?
I use semi-automatic weapons to kill hogs. I use semi-automatic weapons for sport and shooting on our property, but I also have semi-automatic weapons, and I'm getting to the point.
Thank you.
Because a semi-automatic weapon is a weapon that you can use for self-defense. It is a semi-automatic weapon that you can use to defend yourself against home invaders, but also, let's be clear, against tyranny. The gentlelady is talking about the Second Amendment in the context of hunting, as if my rights are reduced in the Constitution to a .410 or a single shot or lever action .22, as if that was what was expressly put forth as how we're supposed to be defending ourselves.
Gentleman yield again?
And let me go ahead and finish my time, sir, unless we want to add more time.
Very, very quickly, question.
I need more time. Will the gentleman give me another 30 seconds?
Yes.
Okay, I'll yield.
You said that you could use a semi-automatic weapon to fight tyranny.
Sure.
You mean you'd use it against American troops?
The very existence of the Second Amendment is designed purposefully to empower the people to be able to resist the force of tyranny used against them to step over their natural rights given to them by God. That is why the Second Amendment exists. That is very specifically why the Second Amendment exists. And let's be very clear about that. Let's rewind the clock a little bit, as I know at least several justices have written in Supreme Court opinions, but about what life looked like in the 19th century and what the government was doing to remove the ability of either slave owners or, importantly, freed blacks, or importantly, whites who even stood up in defense of blacks or against slavery, and the efforts by the South and the efforts by the strong arm of government to remove their ability to have firearms. That is an absolute, undeniable, documented, historic fact in our country. As written by Robert Verbruggen in the National Review, and I'm happy to submit this to the record without objection, he writes, "The heart of the problem is that in an effort to stave off rebellion and maintain the racial caste structure that had developed under slavery, state and local governments refused to respect freedmen's constitutional rights. Crucial to the South's efforts were gun control laws that applied to blacks and blacks alone. This does not show that," and it goes on further, I'm going to take too longer, where it goes into the South's campaign against black gun ownership, not surprisingly, began long before the Civil War. 2 slave rebellions in the 1820s stoked whites' fears, and in response, many legislatures amended their laws prohibiting slaves from carrying firearms to apply the prohibition to free blacks as well. When the government, and he writes further, and I agree with this, when the government has the ability to forbid gun ownership, it has the ability to render groups it dislikes helpless to defend themselves, regardless of whether modern gun control accomplishes its purpose of reducing crime. And for the record, there is no evidence it does. And I agree with that as well. This is so inherent to the very conversation we're having. My colleagues on the other side of the aisle just blithely dismiss due process. A former judge even saying, arguments about due process, you have the opportunity to be heard after. You have the opportunity to be heard after your rights have been taken away. That's the key issue here. We are absolutely destroying the bedrock principle that your rights are given to you by God and that you can't just have to go to the government to ask permission to exercise those rights. And when you
would the
do
gentleman
that,
yield for a question? Could I ask Mr. Roy a question? Would you yield for a second?
I need to finish up my time. I already have a few seconds left over from the chairman. I'm happy to engage with you in colloquies later. And I would point out that my colleague from Maryland, again, just sort of rolled over the fact that it was very expressed in the Supreme Court's ruling that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia. My colleagues like to continually try to connect that to militia service, but we all know that what a militia looked like in 1775 and 1776. I appreciate that the chairman gave me a little extra time in light of our exchange and questioning. I yield back.
The gentleman yields back. For what purpose does Mr. Gates seek recognition? Gentleman is recognized.
Thank you, Mr. Chairman. And I must take note that as we're having this discussion today, the Attorney General is in the Senate, and he was just asked by Senator Grassley, given his testimony in the House, that there was no basis for his decision to create the school board task force in the absence of the letter from the National School Boards Association, and given the National School Board Association's apology and retraction of that letter, would the Attorney General be dissolving the school board task force? Astonishingly, he said he would not, which kind of gives up the game, that this was never about safety for educators or school board members. It was all about chilling parents' participation in the decision-making process that they were aggrieved by, a decision-making process that often embraces pseudoscience, that is reactionary, and that pushes critical race theory, which causes people to hate each other as a consequence of their own skin color or the skin color of the other students or the other professional staff that work in our schools. Speaking of chilling, it certainly seems that there hasn't been an adequate response to the argument that Mr. Massey made earlier in debate, that if this law were enacted, there would be a disincentive for people to seek mental health care. We don't want to live in a country where if someone needs access to that care, that they would be discouraged from doing so, fearing some broader deprivation of their rights. And while I know this must be a very difficult day for my colleagues who have personally felt the impact of shootings and mental health that results in suicide, we have to look at solutions that are actually tailored to solve the problem, not just bills that could potentially exacerbate those problems. And it seemed as though I would love to hear from my colleagues how you would expect people to reach out and get mental health care that they might need if they think that on the back end of that care, they would be deprived of their gun rights. Mr. Chairman, I heard earlier one of our colleagues say that there's just not a circumstance where a good guy with a gun is helpful when there's a bad guy with a gun, and I seek unanimous consent to enter into the record a ABC News piece entitled "Florida School Shooting Heroes Teary Tale, I'm No Hero, Folks."
Without objection.
And in this case, in Bay County, Florida, there was a violent person with a gun that showed up to a school board meeting and opened fire on the school board and the superintendent. And by the grace of God, he was unsuccessful in harming those school officials, but it was an off-duty police officer who was there in a security capacity, who had a firearm and was able to neutralize that shooter. So I think that in my state and in many others, broad deprivations of Second Amendment rights and sort of the de-gunifying of society won't lead to better safety outcomes. I would also take
Would the gentleman yield for a...
Well, I'm making an additional point, Mr. Cohen. And I know you were clear in your comments that you wanted examples from Memphis. So I hope you'll indulge an example from my community where
Thank you. We
guns were
vacation
helpful.
there.
What's that?
I say we vacation there.
Well, we're always blessed to have you. And we hope you come frequently and know that there'll be a lot of folks that are utilizing their Second Amendment rights. It'll be honored to keep you safe. The other note that we've heard a lot about is hunting and self-defense. And I would just note that the Second Amendment is not about hunting and it is not about self-defense. Our founders believed to curate the right balance of liberties in our country so that it would never become necessary to engage, God forbid, U.S. troops with firearms from our citizens. But if we maintain a well-armed citizenry, that creates a balance of liberties and it retards a tyrannical government from being able to be overly forceful against our citizens. So I hope we'll understand that historical framework when debating the Second Amendment. If there are those who think we ought to repeal the Second Amendment, that we don't need armed citizenry to maintain liberties, then let's debate on those terms, not with these sort of paper-cut assaults on the rights that our citizens enjoy and that I believe are granted quite explicitly in the Constitution. And let's also hope that as the American people evaluate the actions of the Department of Justice, they see that a piece of evidence can be the basis for a policy. That evidence can be debunked and the policy can persist nonetheless. It harkens back to the Russia hoax where there was this big lie that Donald Trump was a Russian agent, and then that animated all this activity from the Justice Department that impaired the liberty of Americans, and it seems as though they're continuing on that trend. But now instead of targeting Donald Trump, they're targeting parents who love their kids who show up at school board meetings, and the Attorney General made clear today that he intends to continue doing so. I yield back.
The gentleman yields back. We have a number of bills that will soon be on the House floor, followed by floor votes. Therefore, the committee will stand in recess until immediately after the conclusion of those votes, at which point we will entertain amendments to this bill. The committee stands in recess. The markup will come to order. I will remind everybody to please wear masks or you will not be recognized. The pending question is the amendment in nature of a substitute to H.R. 2377. Are there other amendments? For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Can I reserve a point of order?
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2377, offered by Mr. Fitzgerald of Wisconsin. Page 12, line 4, strike and. Page 12, line 14, strike the period and insert
The
and.
amendment is considered as read, and the gentleman will explain his amendment.
Mr. Chairman, this bill is a red flag law that infringes on the Second Amendment rights of Americans without due process. Under this bill, the Second Amendment can essentially be cast aside with little proof. Further, this bill only goes after the gun and does nothing to help or restrain an otherwise unstable individual. I've yet to see a red flag law that does not infringe on Second Amendment rights. But if the majority insists on pushing forward, we should do what we can to protect innocent people from discrimination simply because the current administration disagrees that people should have certain constitutional rights. My amendment would ensure the First Amendment activities, particularly parents voicing concerns about school board decisions, is not considered a risk factor under this bill. We have already seen the Biden administration attempt to cow parents from speaking out against curriculum pushing critical race theory. I recently joined many of my colleagues on the committee in sending a letter to Attorney General Garland, calling on him to rescind his recent memorandum targeting concerned parents at school board meetings for federal prosecution. At our hearing last week, the Attorney General acknowledged that he issued the memorandum soon after reading about the thinly sourced letter sent by the National School Boards Association to President Biden, in which these concerned parents were compared to domestic terrorists. Parents have an undisputed right to direct the upbringing and education of their children, especially as school boards attempt to install controversial curricula. Local law enforcement, and not the FBI, are the appropriate authorities to address any local threats of violence. The NSBA later expressed regret about the formally apologized for its letter to President Biden. It's critical that we protect both the First and Second Amendment rights of our constituents. This amendment would make it clear that parents can exercise their First Amendment rights without fear of unjustly having their Second Amendment rights taken away without due process. I urge my colleagues to support this amendment to preserve our foundational rights, and I yield back.
Will the gentleman yield for a question?
First of all, is the point of order insisted upon?
No, I withdraw my point of order.
Point of order is reserved. I'm sorry, the point of order is withdrawn.
I was just asking the gentleman if he would yield to a question, but if he won't, I'd seek time in opposition.
No, I don't yield, Mr. Chair. Go ahead.
Okay. Mr. Chairman, I'd move to.
You yield back?
I yield back.
So the gentleman yield back. For what purpose does Mr. Cicilline seek recognition?
I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I rise in opposition to this amendment for a very simple reason. Of course, all First Amendment activity is protected. And in fact, to suggest by this amendment that only parents voicing concerns about school board decisions, that alone deserves special protection and other important First Amendment protections are not likewise protected, seems to me to be a very dangerous precedent. The First Amendment's in the Constitution. Nothing in this legislation would limit the exercise of the First Amendment in any way. And other than this fanciful obsession with school boards, and this apparently is like, we've heard about it now for a week. This seems to be a deep, deep obsession of my Republican friends. But there's lots of First Amendment concerns that are important to respect. And if we just list one, are we implicitly saying all the other areas of First Amendment expression, freedom of religion,
opinions in a variety of other venues are not as important. So I think it's dangerous to carve out one, which is apparently the concern of the day, and suggesting in some way that is entitled to more First Amendment protection than many other expressions that are protected by the First Amendment. So again, this is another effort to create an issue where one doesn't exist, to offer an amendment that is not necessary and adds nothing to the bill, but gives my good friends on the other side of the aisle, an opportunity to talk about something which I think, again, they've completely misconstrued. I think the Attorney General made it very, very clear that he absolutely understands First Amendment rights of people to express opinions at school boards, and parents even expressing those opinions in passionate ways are, of course, protected by the First Amendment, and that his jurisdiction is limited to threats of violence or serious bodily harm.
Will the gentleman yield?
No, I won't. Actually, I'm not done. He said that multiple times during the hearing. He's not here today to repeat it for maybe the 15th or 16th or 17th time. And so my friends on the other side of the aisle keep mischaracterizing what he said. So I'm going to say it one more time. The Attorney General of the United States said under oath that the First Amendment, of course, is respected by everyone, that parents have a right to go to school board meetings and say whatever they want as passionately as they want. And the Attorney General's role and the FBI's role is to protect people who present a danger of violence, serious bodily injury, which, by the way, is being reported in school boards and schools and against educators and administrators, unfortunately, in places all across this country. And the notion that the Chief Law Enforcement Officer of the United States has no role in protecting people who serve as teachers and school administrators and on school boards, has no responsibility to protect them from serious threats of violence or serious bodily harms, is absurd. That's exactly their job. And so it's an interesting discussion point. It gives you an opportunity to mischaracterize what the Attorney General said. Again, it's unnecessary. I urge my colleagues to vote against this amendment, and I yield back.
Mr. Chairman.
For what purpose does Mr. Jordan seek recognition?
Strike the last word.
Gentleman is recognized.
Then why did they apologize? If it's all wonderful, why did they write this letter 24 hours after the Attorney General testified in front of this committee? Paragraph number 2, we regret and apologize for the letter. Same paragraph, we apologize for the strain and stress. Why'd they do that? We haven't mischaracterized one single thing. Mischaracterized the Attorney General. Are you kidding me? The Attorney General just said a few hours ago in the Senate Judiciary Committee that he will not rescind the memo that does this, that sets up a dedicated line of communication for threat reporting, a snitch line on parents. He will not rescind that. Even though the only basis, as he testified to last week, the only basis for the memorandum was what? The school board letter to the president, the same school board letter that that same association has now apologized for. Oh, here's what else we found out from the Senate hearing just a few hours ago. Here's a letter from one of these U.S. attorneys in the state of Montana, one of the 94 U.S. attorney districts, where the Attorney General said, you got to set up a task force in this, you got to convene a meeting within 30 days. Here's what this letter said. The FBI, the United States Attorney's Office, will then collaborate with any interested parties to determine if a federal investigation and prosecution should commence. Who the heck are interested parties? We don't know who that is. Is it the National School Board Association? And the Democrats want to say we've mischaracterized. I'll tell you who's mischaracterized it. Last week, Democrats agreed with the National School Board Association. Here's what Mr. Raskin said. He said, the dark impulses giving rise to conspiracy-driven mob violence, not just in state capitals, but also in schools and school boards. That's just not true. Because if it was, I don't think the School Board Association would apologize. I don't think they would. Certainly not 24 hours after we had a hearing. This is serious stuff. And the fact that the Attorney General of the United States insists on not rescinding his memo makes absolutely no sense to me. But more importantly, I think it makes no sense to all kinds of parents, all kinds of moms and dads around this country who know, everyone sees what this was about. This was political. This was to chill First Amendment activity of moms and dads. And that's why the gentleman from Wisconsin's amendment is so right on target. And I'd be happy to yield to him if he has something to add to the gentleman from Rhode Island's ridiculous comments.
Mr. Chair, I think it's worth flagging because in this particular case, there was a chilling effect. which is, I think, what everyone is concerned about. I mean, any time that somebody in the White House doesn't agree with what's being discussed or what's happening out on the street, I mean, if it's easy enough to just call the Attorney General and say, you know, is there any way you could quickly draft up a memo on this? The chilling effect that that'll have across this nation, I mean, that's what the big concern should be. And I would yield to the gentleman from North Carolina. To North Carolina.
So here's why it's necessary to single out the activity of moms and dads advocating before their school boards. It is because the Attorney General has singled them out. And the Attorney General acknowledged to us in his hearing that the predicate for that was this letter from the National School Boards Association. And that is the letter that the National School Boards Association has now apologized for. The Attorney General should never have acted on the predicate of that alone without doing an independent investigation to issue a memorandum to nationwide law enforcement. And once the predicate, even that predicate has been exploded, he should have the decency and the responsibility to withdraw that guidance, but he has not. And indeed, in the same letter that Mr. Jordan referred to, the letter from the Montana Attorney General, or the Montana U.S. Attorney, it starts off, in response to a nationwide rise in threats and acts of violence against our educational community. There is no evidence of such a nationwide rise. There are isolated reports of someone doing some minor slapping somebody or something. There have been a couple of those arrests. There have been a couple of actually misreported threats. I read every source in the National School Boards Association letter. There is no nationwide rise in threats. And anyone who continues on this committee to repeat that rhetoric should come forward with your evidence. Let's see your numbers. Let's hear your details. Let's understand where the prosecution stands. They do not exist. And in the absence of that, and I got to tell you, members of this committee receive threats from time to time. We don't send out nationwide memos from the Justice Department calling people out.
The time of the gentleman has expired.
Mr. Chairman.
Yes.
I'd ask
For what purpose does the gentleman seek recognition?
thank you, Mr. Chairman. I ask unanimous consent to enter into the record the letter in response to Attorney General Garland's memorandum, the letter from the acting United States Attorney for the district in Montana.
Without objection, I will now recognize myself to strike the last word, and I will speak in opposition to the amendment. First of all, I don't care about the National School Board Association's letter or not, or whether they knew what they were talking about or not. There is ample evidence all across the country of a great rise in threats against school board members. You just have to watch the news every night and you see threats against school board members. And so it is amply justified for the Attorney General to instruct the FBI or whoever to initiate investigations to protect members of school boards, period. But in any event, this has nothing to do with this bill. This bill does not deal with school boards. This bill deals with temporary orders of protection against firearms by people who pose a threat to themselves or others. And that's what we ought to be discussing, forgetting the school boards. This bill has nothing to do with school boards. And the bill simply sets up that when someone is a threat to someone else, when there's an imminent danger of that person using firearms to injure that person, you have 14 days. You can get an ex parte order within 72 hours. You can get an ex parte order lasting no more than 14 days to show on probable cause. And if you want to extend that, you've got to show clear and convincing evidence. And none of this has anything to do with a violation of the First Amendment. It's totally irrelevant. It's to the bill, and I therefore oppose it, and I yield back. Who seeks recognition? For what purpose does Mr. Issa seek recognition?
Strike the last word.
Gentleman is recognized.
Mr. Chairman, you know, one of the things that I observed in looking at this committee over 2 decades is that often both sides get so heated that we lose track that an amendment quite frankly, is going to have no negative or dilatory effect on the bill, even if it offends the other side. And so I would defend that you should be perfectly willing to support this amendment, because nothing in it would unreasonably deter someone from executing this bill. It would certainly not cause any Democrat to not vote for it. And at the end of the day, a statement that may not consider activities protected under the First Amendment doesn't sound all that bad if you stop thinking, oh, we don't get along, Republicans and Democrats. I've been here for a long time. I'm best known for investigations. And what I've found in investigations is that when someone says there isn't something there and wants to shut down an investigation, they do so often out of fear that there's a lot more there than not. And I would say that when it comes to questioning whether or not the Department of Justice is having a chilling effect on First Amendment freedom of speech, whether it's school boards or anywhere else, we should all be willing to say, we don't know it. In just a moment. We don't know that there isn't a there there, or there is a there there, but we ought to all be willing to go down that road, even if at the end of the day, it's a dead end. I remember the IRS situation, one in which there was no there there, but at the end of the day, the person who conspired to do it resigned or retired and took the fifth. So I think all of us would be better off allowing the process to go forward and to protect the First Amendment, and I'd yield to the chairman.
I thank the gentleman for yielding. I was just intrigued by your comment that when someone says an investigation is not necessary, it usually is necessary. I've heard every single member from your side of the aisle, other than yourself so far, talk about how an investigation of the violence against school boards is not necessary. And your logic would lead us to say, well, that means that it is necessary. And I concur with that. It is necessary.
Reclaiming and hopefully properly using my time, I respect the U.S. Attorney's right to do investigations. I don't respect their right to put out a broad spectrum of a letter like this that would have a clear chilling effect on parents simply going and doing what they have done for generations at school boards, often heated, often frustrated. And that's even in the best of schools and perhaps the most benign of parents. You give a parent a feeling that their child isn't getting the proper education, and a lamb becomes a lion. Having said that, it is how it was done that offends me, not the fact the Department of Justice could, on individual and isolated basis, be looking for violence. What I would say, though, is that the Department of Justice today has plenty of violence to look at without having to look for the threat of violence, and I think there's a real point there. But I thank the gentleman for pointing out that sometimes when, in fact, there isn't, there is. Maybe there is some, no question at all. But you don't have to send out a letter to 94 U.S. attorneys. You don't have to intimidate every parent and put them in fear because somebody gets overheated or takes a swing in a public meeting, whether it's a school board or, in fact, a city council meeting or any other sort of place. Those things do happen. For the most part, they are not and should not be federal offenses. They are, in fact, local issues. And I would hope that the U.S. attorneys would be working on those issues for which a district attorney is unable to investigate or prosecute. And I thank the gentleman for his comments, and I yield back.
The gentleman yields back. For what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. I just have to absolutely say that I'm urging my colleagues not to support this amendment. It is a partisan attack, and it's meant to distract us from the essence of what this legislation really means. So let's get back to talking about what this legislation really is meant to do. And I'd like to refer to earlier what Congressman Fitzgerald said, that this bill was written by the Biden administration. And this could absolutely not be further from the truth. This bill was originally drafted through a bipartisan collaboration between Senator Lindsey Graham and Senator Richard Blumenthal. And it is based off what we have learned from the successful bipartisan efforts of the many states that have passed similar laws at the state level. Many Republicans have actually supported extreme risk protection laws. In 2019, after the terrible back-to-back shooting in El Paso, Texas, and Dayton, Ohio, President Trump said, and I quote, "We must make sure that those judged to pose a grave risk to public safety do not have access to firearms. And if they do, those firearms can be taken through the rapid due process," end quote. That was President Trump. Senator Ted Cruz said extreme risk laws are, and I'm quoting once again, "a law enforcement tool that can be helpful in preventing crimes of violence," end quote. This is not about politics. These laws protect the Second Amendment rights of responsible gun owners by targeting only those that are presenting a risk to themselves or to others. This is not about politics. This is about saving lives. So let's get back to the essence of what we need to be debating and stop all of this frivolous rhetoric about everything else that we want to talk about. We're here to talk about saving lives. Let's do that today, because you have constituents in your own demographics that need the protection of this bill. And I yield back the balance of my time.
The gentleman, the gentlelady yields back. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
I thank the chair. I would note that my colleagues on the other side of the aisle want to dismiss the concerns that we are putting forth about what's happened with respect to targeting school boards. I understand why they want to do that, because they certainly don't want to talk about school boards, because the American people are waking up to the blatant attack on the rights of parents going on currently in schools across the country. There are signs dotting Northern Virginia right now, right, because there are races going on. There's a sign I drove by this morning. It says, "Keep parents out of classrooms." Keep parents out of classrooms. That's the story. Mm-hmm. And that's the story that my colleagues on the other side of the aisle do not want to address, because they know full well the American people are absolutely sick and tired of having politicians get in and start teaching their kids that America is evil and go into the classroom and go into the school boards and take over the schools and hide it from parents. But the one upside of this disastrous virus is that the veil has been lifted on a corrupt school system that has been undermining our American children for generations. And my colleagues on the other side of the aisle know it. The campaigns going on in Virginia and New Jersey, the campaigns know it, and they're running away from it, and they're seeing the disaster that has unfolded with the Attorney General of the United States targeting a father defending his little girl who was raped in a bathroom. That's the truth. That's the reality. And we're bringing it up here in the context of a bill, another bill by my colleagues on the other side of the aisle, targeting Americans, targeting our Second Amendment rights and our ability to defend ourselves against tyranny. And then my colleagues say, well, why do we need to talk about that here? Well, you tell me. You tell me whether I should trust the Department of Justice not to go after Scott Smith and to go after Scott Smith and take away any firearms he might have.
Yeah, good point.
You tell me whether Scott Smith wouldn't be Exhibit A of the kind of citizen in this country who would be targeted by an attorney general that's now got his U.S. Attorney's Office putting out 13 crimes to go after parents and to go after and target people in school boards, when Mr. Smith was bloodied and arrested in a school board meeting for simply going forward and trying to defend his daughter, after the very school board in question lied, and covered up a rape of his daughter on May 28th in a bathroom in a high school when she's in the 9th grade in Loudoun County, Virginia. They covered it up, they hid it, and then what happened just a few weeks ago at Broad Run High School, just a few miles down the road, but another young girl was assaulted by the same boy. That's what occurred. But my colleagues on the other side of the aisle don't want to talk about that. What they want to talk about is using the power of government. Using the power of government to walk into people's houses and take away their ability to defend themselves. And they want to hide behind, oh, we're going to provide due process. But don't mind the fact that that due process occurs, supposed due process, fake due process, that occurs after their rights have been stripped away, after the power of government has come into their homes and taken away their firearms. That's the actual truth. I listen to my colleagues on the other side of the aisle talking about, oh, well, we have a right to be free from fear. We have a right to be free from violence. No, there is a duty in the Constitution for us to secure the blessings of liberty. We have a duty in government to protect the citizenry. One way to do that, by the way, is not to defund the police. One way to do that is to actually stand behind law enforcement so that we can have secure communities, as our constituents expect us to do. One way to do that is to ensure that the citizens are in fact able to arm themselves and defend themselves when government abandons them. Abandons them just as they are right now on the southern border of the United States, where cartels have operational control of our border, where people are pouring into Texas. Fentanyl is pouring into Texas. Danger on our streets. People dying from fentanyl overdoses. And then we have people dying across this country because we have gangs and violence increasing and murder rates skyrocketing. Why? What would the correlation be? Is it because we need to have some sort of red flag law to go after an American citizen's rights to defend themselves? Or could it be that we've abandoned any concept of what justice should actually look like in this country, where we can actually have security in our streets rather than pulling cops off the streets as they did in Austin, Texas, and we watched the murder rate skyrocket? There is a correlation here. We are talking about rights, and we know full well that the same people that would go after our gun rights would target Scott Smith because he dared to speak up at a school board in Loudoun County, Virginia. I yield back.
Gentleman yields back. For what purpose does Ms. Jackson Lee seek recognition?
Mr. Chairman, I rise to strike the last word and to discuss the underlying bill. I thank the chairman very much. I want to thank Congressman McBath again, because really you would, really at this moment, with as much has been thrown at you, give you accolades for your courage. You did not have to lead on this legislation. We've known from the time that you've started on the Judiciary Committee that you have a personal hurt that will never go away. And many times that hurt is kept to that person's self, and they do not put themselves out to do what is right and good for the American people. I'm grateful that you have done that, and I'm grateful that you have spoken about guns. Now, someone might begin to say, oh, don't read the Second Amendment, because as we all know, it has been manipulated and utilized and expanded over the centuries. But I am compelled to read Amendment 2. A well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. Tied, of course, to the security of a nation. It has become many things to many people. But one thing that Florida and Indiana know, Republican-led states, that red flag laws work. And to associate a rightful letter by the DOJ to ensure the safety and security of parents, school board members, children in the discourse of education, and to tie it into a life-saving tool that has been used by 19 states is ludicrous. I will rush to the aid of that dad who is seeking information. As a parent, I have stood before school boards, not only for my children, but I've stood before it for throngs of children. I have never raised my hand to slap a parent. I've never tried to slap a school board member. I've never tried to struggle with a gun. And it has been some heated meetings, and I'm from Texas. We've had some discussions. When you speak about the children you love, you are passionate. I don't think the Attorney General in any way disregards that passion. Whoever put that sign up, God bless him, I'll take it down. Because I don't know who would stop rightful parents from being in a school board meeting. As far as I know, if a school board allows a public session and opens it up for individuals who signed up to speak. They're the closest thing, even beyond city councils, for that town hall style meeting. My superintendent is out in the community, letting parents speak at schools in off hours. This bill deals with saving lives. It has an ex parte provision. There are requirements, 14 days. And then if you want it longer, 180 days, you have an indicia of criteria that you must present. It is not taken lightly. And next go round, I'll acknowledge that. But I want to add this into the record, Mr. Chairman, and read these words. It is Tipps's warning to FBI and Florida shooting suspect. I know he's going to explode, and forgive me for those who have a sensitivity to Parkland. I do, but I'm not from Florida. But allow me to read this. I know he's going to explode. A woman who knew Mr. Cruz said on the FBI tip line on January 5th. Her big worry was that he might resort to slipping into a school and just shooting the place up. 40 days later, Mr. Cruz accused of doing just that, barging into his former high school in Parkland, Florida, and shooting 17 people to death. 3 months before the February 14th massacre of Marjorie Stoneman Douglas High School, a family friend dialed 911 to tell the Palm Beach County Sheriff's Office about Mr. Cruz's personal arsenal. I need someone here because I'm afraid he comes back and he has a lot of weapons. Red flag laws. Not denying him his due process, but from a dangerous potential person who had guns. How many lives could be saved? And so I believe we should support this bill enthusiastically. It is constitutionally grounded, and it has nothing to do with the DOJ's responsibility to teachers, parents, and school board members for their safety and security and their children. I yield back.
The gentlelady yields back. For what purpose does Mr. McClintock seek recognition?
To speak on the amendment.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to begin by returning to the letter that Mr. Jordan cited, where the acting U.S. attorney in Montana notifies everybody, all county attorneys, sheriffs, the Office of Public Instruction, the School Boards Association, the FBI, quote, the FBI and the United States Attorney will then collaborate with any interested parties to determine if a federal investigation and prosecution should commence. Investigation and prosecution over what? Well, he helpfully lists a number of things: anonymous telecommunications harassment, making repeated calls to your school board member, repeated harassing communication, all grounds for prosecution. And the assurance we hear is, well, if parents attend a school board meeting and don't get out of line, they've got nothing to fear. Well, Professor Jonathan Turley pointed out that's about as reassuring as saying you're going to be followed everywhere you go by a patrol car, but you've got nothing to fear. Are you going to drive more or less under those circumstances? The fear expressed to me by a number of parents is, well, what happens if I attend a school board meeting and some yahoo makes a veiled threat or a fight breaks out on the other side of the room, and suddenly everyone who came to that meeting gets a visit from the FBI? That's chilling. And its obvious purpose is to add enough risk, enough fear, to convince enough parents not to assert their right to petition their government for a redress of grievances, one of the most fundamental rights of a free people. Now comes before us a bill that says, well, your firearms can be seized in a secret proceeding that you don't even know has happened until it's over, because somebody thinks you might pose a danger, but they can't prove it. The question arises, would it be enough? Would it be probable cause to say, well, this person is under investigation by the FBI because they attended a meeting and they were seen cheering someone who said, we're coming after you in the next election, which was interpreted as a threat by a school board member. Now, in days past, such fears would seem fanciful, if not preposterous. Unfortunately, these days, not so much. So I applaud this amendment. I think it illuminates the intent of the majority that are supporting both of these policies. Yield back.
The gentleman yields back. For what purpose does Mr. Big seek recognition?
We'll strike the last word.
Gentleman is recognized.
Thank you. I'll yield to my friend from Colorado, Mr. Buck.
I thank the gentleman for yielding, and I want to associate myself with the remarks of Mr. Roy from Texas in his analysis of this amendment and the current situation, with one exception. And I wanted to just ask Mr. Roy a quick question, but you mentioned that it was a boy, quote unquote, who attacked this young girl in Loudoun County. The left uses these phrases, and the media uses these phrases in ways that really tend to shift the focus away from their pet projects. But according to the left, when a boy puts a dress on and declares himself a girl, he is a transgender girl. When a boy puts a dress on and commits a crime, then he is a boy, because they don't want to admit that transgender girls, transgender women, shouldn't be in women's shelters. After a woman gets brutally beaten by a man and seeks refuge in a woman's shelter, the last thing she wants to see, in my experience in law enforcement, is another man. And so to make men to give men access to a woman's shelter because they dress like a woman is something the left is parading around and advocating for. They have to call what happened in Loudoun County a crime by a boy. Can't call it a transgender girl. I was just wondering if my friend from Texas had any thoughts about that.
I appreciate the question from the gentleman from Colorado. Obviously, the facts in question that led to the situation where Mr. Smith was dealing with the circumstances in July before the Loudoun County School Board is that school board's obsession with woke politics involving transgenderism, transgender policies, and talking about how important it was for that school to embrace such policies, and therefore creating an environment in which this, I assume, biological boy was able to be in the girls' bathroom when this 9th grade girl was therefore then raped, sodomized in the bathroom of a high school that her parents sent her to be educated. Now, interestingly, it was in Broad Run High School a few weeks ago when the other young girl was assaulted by this, again, I believe, a biological boy, and that the defense by the boy, biological boy, was that his skirt got caught on his watch, and therefore in something going on in the bathroom, he then therefore assaulted this girl.
The second time.
The second time. After he was then let free, of course. After he had been brought forward and charged, was let out. And the school board covered it up. This is the circumstances. This is the environment. This is the reason parents are so frustrated and angry. Which is it? Is this a boy or is this a girl? And then does it matter? And to your point, as a former U.S. attorney and someone who worked in law enforcement, as you did, right? When we're talking about shelters and protecting women, which is it? Is it a girl or is it a boy? And don't these things matter? Don't fundamental truths matter? And I yield back to the gentleman from Colorado.
And I yield to my friend from Arizona.
Thank you. So the chairman mentioned that there's been ample evidence of a rise in threats at the school board level, and rather mystically, like the Attorney General testified just last week, he couldn't produce any. Rather mystically, like the National School Board Association, they couldn't produce any evidence either. And we've been having trouble in my office finding that evidence. Well, so on page 11 of the bill, when you start looking at the factors, and you start coupling the factors that are going to give someone basically a lack of due process, and remove their private property rights, and effectively punish them with some ex parte hearing, you add the AG's directive in there, which implies and imputes that parents going to school boards might qualify under line 14, page 11, factors to consider here. And you begin to see why this amendment not only is rational, it is necessary. The removal of one's property rights, the removal of one's given rights before one is given a hearing isn't
Time
due
of the
process
gentleman has
at all.
expired. Let me remind everyone, please wear your masks, and if you don't, you will not be recognized to speak. For what purpose does Mr. Massey seek recognition?
I move to strike the last word.
I don't think you're using your mic.
Can you hear me, Mr. Chairman?
Yes, now we can.
Okay. I'd like to speak in favor of the amendment.
Gentleman's recognized.
Does the gentleman from Arizona wish to have some more time to finish his last statement?
I will wait till you finish your statement,
Okay.
and then I'll proceed if it's possible.
Thank you. Well, here we are debating red flag laws. They're completely redundant because every state has laws to deal with people who are a danger to themselves or others. It's unconstitutional. It turns due process on its head. But I heard something earlier in the debate that I just can't let slide. One of our colleagues from Tennessee said he didn't know of a single instance where a good guy with a gun has stopped a bad guy with a gun. It's literally the only way to stop a bad guy with a gun is a good guy with a gun. So I'm going to inform the gentleman from Tennessee, if he's still in the hearing, of several instances of good guys or women stopping bad guys with the gun. On May 15th of this year, an attacker at an apartment complex in Fort Smith, Arkansas, fatally shot a woman and then fired 93 rounds at other people before a man, a good guy, a man killed him with a bolt-action rifle. Police say he likely saved a number of lives in the process. This is a good guy with a gun stopping a bad guy with a gun. On June 30th, a 12-year-old Louisiana boy used a hunting rifle to stop an armed burglar who was threatening his mother's life during a home invasion. Well, that's a good boy with a gun stopping a bad guy with a gun. On July 4th, the Chicago gunman shot into a crowd of people, killing one and wounding two others, before a concealed handgun permit holder shot and wounded the attacker. Police praised him for stepping in. Again, good guy stops bad guy. This is literally the only way to do it. In fact, don't take my word for it. Don't take the media's word for it. In fact, this year alone, over 1,000 reports in the media who are very reluctant to report these sorts of things gave stories in the media of good guys who stop bad guys with guns. The U.S. Department of Justice's National Crime Victimization Survey indicates—
Would the gentleman yield?
Let me finish, please. That around 100,000 defensive gun uses occur each year. An estimate that, though it may seem like a lot, is actually much lower than 17 other surveys. The other surveys find that between 760,000 defensive handgun uses and 3.6 million defensive uses of any type of gun per year, with an average of about 2 million. This comes from an article that I'm going to ask for unanimous consent to submit to the record, entitled "There Are Far More Defensive Gun Uses Than Murders." Here's why you rarely hear of them. Dated September 22nd, 2021 by John R. Lott Jr. and printed in Real Clear Investigations. I ask unanimous consent to submit this article for the record.
Without objection.
And I would yield 30 seconds to my colleague from Tennessee.
Thank you very much. There are some instances indeed, and I said there were no instances in the country. I was certainly wrong, and I got too hyperbolic. There are not that many, though, and there have been none in Memphis.
Mr. Cohen,
and I
we're
don't believe
unable
there
to
have been thousands in the country.
Mr. Cohen, we have a technical problem and are unable
Tweets
to
and your
understand you.
response and the group that had it. I think that's overblown. But the bottom line is that's not the issue. Is when you have a red flag and save people's lives.
Reclaiming my time, and I hope somebody else will yield Mr. Cohen more time when his audio-visual problem is solved. You know, the reason you get differences between the 100,000 number that our own U.S. Department of Justice says is the number of defensive gun uses each year, and the million-plus number,
is because the surveys the difference arises from the screening question. If the survey asks if somebody is a victim, if they first ask if the person has been a victim of a crime, only respondents who answer yes are asked if they have ever used a gun defensively. In other words, you don't consider yourself a victim, and so you don't complete the survey if you actually used the gun and prevented yourself from being a victim. So that's why the U.S. Department of Justice's number is so low. By low, I say 100,000. Even with the slanted survey, they confirm there are 100,000 defensive uses of guns every year. Other surveys show up to 3.6 million. And with that, if my document has been submitted to the record, I yield back.
The gentleman yields back. Who else seeks recognition?
George Johnson suggested he and I have dinner.
Is Mr. Raskin seeking recognition? You're muted. Does anyone seek recognition?
Yes, Mr. Chairman. Mr. Chairman.
The gentleman is recognized.
Thank you very
Before
much.
he starts, would you yield briefly to me, please?
Yes, I yield to the chairman. Happily.
Thank you. I just wanted to wonder what Mr. Roy's extensive discussion of transvesticism has to do with this bill. I yield back. I yield back to Mr. Raskin.
Calling things said today, but perhaps the most shocking one for me was the suggestion that the Second Amendment gives the citizens of the United States the right to raise arms against the government if we perceive tyranny taking place. And I wonder if my friend from Texas, Mr. Roy, would yield for a question, because what it made me think about was Derek Chauvin's murder of George Floyd. There were a number of citizens who gathered around there. Did they have the right to use their weapons to kill Derek Chauvin at that point?
My friend from Maryland, is going to go through asking hypotheticals about these situations. My friend from, I can't remember.
That really happened.
One of my colleagues on this side of the aisle made the point that the purpose of this is to create the barrier to which the government knows that if the people have the ability to arm themselves, they can push back against tyranny. As I explained earlier about Black Americans
I'm just
who
trying
were
to
denied their ability, their God-given right to defend themselves.
I'm trying to concretize your point. There have been a number of cases of officers killing unarmed African-American suspects, and you raised this in the question of race and the right of African-Americans to defend themselves. And I just want to be clear what your position is the purpose of the Second Amendment to give people the right to use armed force against police officers in a situation like that. That's nothing hypothetical about it at all. Derek Chauvin has been convicted of murder. So I just want to know, could George Floyd or any other person observing that scene have used a weapon to kill Derek Chauvin in order to disarm that exercise of tyranny against a citizen?
Well, we could have a long discussion about this professorial style, as I'm sure you would enjoy, and so would I. But the reality is, the point of the Second Amendment is to make a very clear statement about who has the power in this country. That's the point. The laws exist on the books. And yes, there are examples where people have used firearms defensively to defend themselves, and including law enforcement personnel when power is being used the wrong way. And if there's a law enforcement officer raping a young woman and that woman pulls a gun and kills the law enforcement officer, she should. That's the point.
Okay. All right. I just wanted to be clear about that, because you're sending a very tough message to the public about the use of force against officers who may be abusing their authority. The Supreme Court in
Would the gentleman yield for a moment?
Yes.
Mr. Roy answered the question when I asked, does he think that people may use armed force against American troops? And he said yes. He said yes. In defense of tyranny, you can use force against American troops, and everything else would follow. I yield back to Mr.
Gentleman, yield. That was not what I said.
Mr. Roy, I'll yield to you in 1 second, but maybe you'll incorporate an answer to my question. the people who attacked us on January 6th, wounding and injuring more than 140 officers, as you know, breaking people's noses and jaws and vertebrae and arms and so on, and giving people heart attacks. Those people were claiming that they were opposing tyranny. They used exactly the language you did. They said this was 1776. Some of them said it was Civil War Part 2. Do you think that they were justified in taking up arms against the U.S. Congress on that day?
I don't accept your characterization, but what I would say to you is to my friend.
You don't? Well, which part?
No, I don't. The idea that you're saying that the way you characterize the events of January 6th, I don't accept your characterization of that. But what I would suggest.
Wait. Well, what part do you not accept? You don't accept that there was violence and that we suffered more than 140 injuries on our police force defending our lives?
Of course, I understand that there was violence on January 6th, but what the gentleman from Maryland is suggesting is that somehow that's tied to the existence of a Second Amendment right and the ability of people to defend themselves as they need to be able to defend themselves. That's what you're trying to characterize and draw the line. That's what you're suggesting.
No, I'm not suggesting anything. I'm asking you this question, which is you were saying the purpose of the Second Amendment is to allow the people to defend themselves against tyranny. That's precisely the language being used by those who are defending the violent assault on Congress on January 6th. Were those people justified in taking up arms?
The gentleman has expired.
And he can answer. Can he answer that, Mr. Chairman?
I'll permit that.
The gentleman's time's expired, but I'll be happy to continue to address.
The gentleman's time has expired. For what purpose does Mr. Tiffany seek recognition?
Move to strike the last word, Mr. Chairman.
The gentleman is recognized.
I'd like to yield time to the gentleman from Colorado.
I just want to answer Mr. Raskin's question. No, you may not kill a police officer, ever, period, end of story. Okay, Mr. Raskin? Just want to make sure that is really offensive that you would suggest.
Oh, wait.
No, I didn't ask. I didn't yield time, Mr. Raskin. You know what the rules are. I didn't yield time. You can get time from one of your colleagues. But we have all watched what's happened in the socialist country that you folks are trying to make this. We have watched in Venezuela as they have taken the guns away from people and then empowered thugs to enforce their laws against innocent people. We have watched Venezuelans screaming across our border so that they can live in the land of the free. We have watched other countries as they have disarmed the public and then allowed the government to impose tyranny. And we will not stand for that tyranny in this country. And the government knows that we are a well-armed people that won't stand for it. Don't confuse that with killing a police officer. I yield back to my friend from Wisconsin.
Thank you very much. So I rise in support of the amendment here from the gentleman from Wisconsin. And let's be real clear here. You know, in reading this memo that came from the United States Attorney in Montana, it's very clear that this is meant to have, at a minimum, a chilling effect and possibly intimidation in saying to people, be careful going to these school board meetings if you're going to raise your voice because it may be the feds coming for you. We're watching you. I asked in the hearing last week of the Attorney General, did any states ask for help? He did not answer the question. And we all know what the answer is when they do not answer the question. States did not ask for help. This was set up by the Biden administration to send a chilling message to parents. Hey, as the candidate for governor in Virginia has been saying, you parents don't have a role in your schools. The government will take care of how your schools are run. Now, I paraphrase a little bit there, but that's in effect what the Democrat governor for candidate from Virginia said. Hey, you parents, you don't have any role in your schools here. We will take care of it. And parents across the country have gotten the message. But you also think about all the stuff that has happened here over the past 10 months. And I think the culmination of it is the trillions and trillions of dollars that are going to be spent or proposed to be spent in these bills that are being contemplated right now, 87,000 new IRS agents. Think about it. 87,000 IRS agents. Will anybody be safe? They are coming after your bank account. They don't want parents at school board meetings. The message is clear at this point. And that's why this amendment is so important. Gentleman from Texas, do you need any time?
Sure, I'd be glad to.
I yield to the gentleman from Texas.
Well, I appreciate that. And to be clear, I associate myself with the remarks of the gentleman from Colorado as someone who's, as many people on the other side of the aisle, whose families and people have served in law enforcement. My grandfather's a police officer. My great-great-grandfather was a Texas Ranger. I worked in the U.S. Attorney's Office. I very much respect and admire all of those who are working in law enforcement. And of course, the rule of law is what governs in our country. And to have the other side want to try to turn that on its head when what we're talking about here is the reality of the ability of the citizenry to be able to, and as the gentleman from Colorado rightfully noted, create that, essentially, if I'm going to use a term from First Amendment jurisprudence, the wall of separation, the ability to be able to prevent the growth of government, the tyranny of government when they know that their citizens are armed. That is just a simple reality of our founding and our history and who we are as a country. And it is a very profound recognition of what the reality was in 19th century America and the purposeful, specific de-arming of Black Americans, white Americans who stood alongside Black Americans, freed Black Americans, slave Black Americans who were being denied the ability to live free. It's historic, it's purposeful, and it was done. And the whole point here is that an armed citizenry is what holds that line for being able to ensure the government does not grow too powerful. I yield back.
Yeah, thank you very much. And I would just close with this, Mr. Chairman. The federal government is getting involved in a place that it doesn't have to. The gentleman from Kentucky has made this point a couple times. We have Chapter 51 in the state of Wisconsin that deals with an involuntary confinement. All states have this, but out of the issues that the states can handle better than the federal government. I yield
Gentleman's time is, the gentleman yields back. For what purpose does Ms. Garcia seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized, and you might want to speak closer to your mic.
Okay. Sorry, I was in the middle of two mics and I used the one on the right. I should have stayed away from the right. I just want to say that I strenuously am opposed to this amendment, and I want to repeat some of the words or paraphrase some of the words of the author of the bill. I mean, let's get back to focus. This is about red flag laws. The word school board, I don't think is anywhere in this bill. I don't think that we should even be talking about all this. It just seems to be such a deviation and a waste of time to continue some of this dialogue. But in the interest of making sure that we hear Mr. Raskin's response to some of the comments that were made, I know he was anxious to do so, but was not given time. I yield the remainder of my time to Mr. Raskin.
Thank you, Ms. Garcia. Look, the Second Amendment, according to the Supreme Court in the Heller decision, protects all of our right to carry a gun in self-defense, and everyone's right to possess weapons for the purposes of hunting and recreation. It is also subject, according to Justice Scalia and the majority of the Supreme Court, to reasonable regulation in the interest of public safety, the overwhelming interest in public safety. So the suggestion that there's an additional right to use a weapon to protect yourself against what you perceive as tyranny is not based in any Supreme Court precedent. That is not based in anything that has been written by the Supreme Court. And of course, it's precisely what was invoked against us when there were people who came to storm the Capitol of the United States to interrupt our counting of electoral college votes and to wound and injure 140 of our officers, many of whom are still suffering the wounds from that day, both the physical wounds that were inflicted by a rampaging mob, and then also post-traumatic stress syndrome and all of the psychological and emotional effects of that. You want to talk about attacking police officers? That was a bunch of people attacking police officers, spouting all kinds of propaganda and nonsense about a stolen election, mimicking the claims of Donald Trump, despite the fact that more than 60 federal and state courts have rejected every claim of electoral fraud or electoral corruption. So you want to talk about factual relativism and moral relativism, talk about Donald Trump and this movement that he has created to question the federal judiciary, to question the actions of Congress, to question election officials, like Republican election officials, like the Secretary of State of Georgia, Brad Raffensperger, all of whom reject these false claims. And yet now they come in citing their interest in stopping tyranny and 1776 and so on, and wage violence against our officers. So I'm just saying this rhetoric is getting very dangerous. And I'm glad that Mr. Buck intervened to restore some semblance of sanity to the discussion. People do not have a right in the United States of America just to take up arms against the government under the Second Amendment. And that is not what the Supreme Court has said. And at another point, I would love to engage in an historical exegesis about what the Second Amendment is really about, because its history is very much intertwined, as I think my colleague from Texas was beginning to intimate, with the history of slavery and the attempt to make sure that state militias could put down slave insurrections in the country. But I'll yield back to you, Mr. Chairman.
Would the gentlelady yield?
No, reclaiming my time, I yield back to the chairman.
You won't yield?
I thank the gentlelady for yielding. I want to simply point out the logic that we heard from Mr. Roy, whether he realized it or not. He said one of the purposes of the Second Amendment is to enable Americans to defend liberty. And I said, does that mean they can shoot American troops? They can oppose American troops? He in effect said yes. And then when he said, well, if a woman is being raped, she can certainly shoot the police officer. Well, how about someone else shooting the police officer if he believes that the police officer is doing something wrong? That way lies anarchy. And I would also observe that none of this has anything to do with this bill or this amendment. And I yield back.
I've got 1 second, I yield back.
The gentlelady yields back. For what purpose does Mr. For what purpose does Mr. Gomer seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you. With regard to the comment that Second Amendment was to help put down slave insurrections, what my friend was talking about earlier was actually at the beginning of the National Rifle Association that was created in part to ensure that Black Americans would have the right to keep and bear arms, because there were bigoted, biased people and rules, laws that were trying to prevent African Americans from having guns, and the effort was to make sure that they had them. Most people don't realize that's at the basis, the foundational principles of the NRA. Everybody had the right, including African Americans. So in those days, there was nobody asserting the Second Amendment more vigorously than those who were supporting Black Americans' rights to have guns. And with regard to the comment again that there was no fraud anywhere in the country, that simply wasn't true. Can I yield to my friend from Arizona to indicate that? Okay.
So I thank the gentleman for yielding. So the rhetoric that constantly says that those who considered that there was election problems lost 60 cases. In Arizona, they won multiple cases dealing with this issue. I'd encourage the gentleman from Maryland to take a look, because there were some victorious cases there. The next point I would make is when we talk about the necessity for this particular provision offered in the amendment by Mr. Fitzgerald, Mr. Tiffany has correctly put out that this has been the expansiveness of government intrusion in virtually every area of your life, and the fact that we have an Attorney General that is encouraging all Attorneys General to put the damper on free speech at school board meetings, including a report that came in that the Fairfax County mom who attended a Fairfax County School Board confirmed that the Attorney General sent feds and a helicopter to intimidate parents at that school board meeting. It leads one to understand that an ex parte proceeding where the due process takes place after the loss of rights and the effective punishment, because that's what it really is no due process at all. There is a rationale here for this particular amendment, and that is to protect people who are exercising legitimate free speech rights at school board meetings. And with that, I'll yield back to the gentleman from Texas.
Thank you. And just quickly, this memo or letter from the U.S. Department of Justice, U.S. Attorney District of Montana, points out the state of Montana has similar criminal laws against threatening, committing acts of violence, and it may be more appropriate that investigation, prosecution under those statutes. Well, that's exactly why we don't need the federal government rushing into local law enforcement issues, so that, say, someone in a position of power uses that power in order to flex the muscle so that his son-in-law can make vast amounts of money. You have a Fed that can come in and investigate and see if there's corruption there that needs to be dealt with legally. But when it's the feds that are engaging in potential corruption, then who gets to investigate them? I yield my remaining time to the gentleman from Colorado.
I thank the gentleman from Texas for yielding, and I wanted to address a point made by the gentleman from Maryland, Mr. Raskin. Mr. Raskin, let's just be absolutely clear. Not a single gun was found in the United States Capitol on January 6th. Not a single gun was brandished in the United States by the rioters, by the people entering the Capitol. Obviously, the police had guns. But you suggest that there's some nexus between the Second Amendment and January 6th. There is no nexus. There was not an armed... No, I'm not going to yield. There was not an armed insurrection, and I appreciate you pointing out the Heller case and the individual right.
Time of the gentleman has expired.
I yield back.
For what purpose does Ms. Sparks seek recognition?
To strike the last word.
Gentlelady is recognized.
Thank you. I was listening to this discussion, and I grew up in totalitarian country where individuals didn't have rights, law-abiding individuals didn't have rights and didn't have rights to own guns. And that is actually the first thing that totalitarian country under Stalin did, to take people from law-abiding citizens to guns. So only two groups of people had guns. It was the police and bandits. And the Soviet government used police, and if they couldn't to suppress people, then they used bandits on people. And that is what suppression is. So this right empowers as an individual, and it's a very important right. And this is a very important discussion to have. If we talk about, red flag laws, Indiana had them since 2005, and I'm not going to point out how bad provisions of this law I think my colleagues did. We put with due processes, with proper processes, the laws, not really overreaching as this bill, not really federalizing. But unfortunately, it would be that easy. We could prevent, crimes, but laws do not prevent crimes. We had, school shootings. We had just recently at FedEx facility shootings. So it's not going to stop, unfortunately, bad people that are going to try to do bad things. But if we're going to have a legitimate cases, we're going to help people, we have to respect constitutional right, and this bill doesn't do it. But talking about violence, if we're going to talk about violence, Indianapolis has some of the highest crime rates in the country. So definitely doesn't have this violence. But if we're going to talk about violence and anarchy, why don't we talk about what's happening in our border? Drug trafficking, human trafficking, and lawlessness and anarchy on this border, which increases violence in a lot of cities. Why are we talking about not defunding the police and vaccine mandates on policemen that a lot of people now live in the police force? That is increased violence in these cities. Why are we talking about only a third of our children and can read and write by grade 10, and a lot of cities and urban communities, only tens of children can do that. That has created a lot of problems. And why don't we talk about issues that really create violence and why we have this increase in violence, not trying to take rights from law-abiding citizens and suppress? Because unfortunately, our government, now FBI using warrantless surveillance, Department of Justice intimidate parents at school board meetings. We have IRS going to be collected information on people. We're becoming like a surveillance state, like a totalitarian regime. And this breaks my heart to see that. So I think we need to have a serious discussion about what we can do to reduce violence, and a lot of them actually happen in the Democrat-run cities, but we need to help them. And I represent one of the cities. I want to be helpful, but let's have serious discussion and protect rights, constitutional rights of individuals, and write these laws that they don't infringe on our rights, because this is the only difference between our country and any other country in the world. That's why people want to come here. We're the greatest country in the world because people have the most freedom protected by our Constitution. And the only function we legislators have, that people gave us right to be here, to protect their rights to life, liberty, and property. That is the only reason. People gave us the right to be here. And we have to think, how do we protect their rights? Don't infringe on their constitutional rights. And it's extremely important discussion to have. But unfortunately, we cannot have this discussion right now because no one wants to have a serious discussion. We have a lot of drama, but this is a pure infringement. And the way how this bill is written, it's infringement on people's rights. And we cannot be the government of suppression. We have to be the government of liberties and freedoms. And I hope my colleagues can work on some of this issue, how we can make sure that our future generation can experience this great country as our previous generations. And I yield back. Yeah, I yield.
When the gentle lady said that in the totalitarian country she left, the only people who had guns were bandits and government, reminded me of the saying that the police can be there in minutes when seconds count. But if you look at the Democratic-controlled cities that have defunded the police, it's now hours before the police are there. I think it's ironic that in those democratically controlled cities and states, officials have released dangerous criminals back onto our streets. They've refused to prosecute crimes. They've reduced police forces. They've refused to deport criminal illegal aliens, instead releasing them back into our neighborhoods. And while doing all of this, at the same time, they seek to make it harder and riskier for law-abiding citizens to maintain the means of protecting themselves. I find that ironic, curious, and disturbing. And I thank the gentlelady for you.
The time of the gentleman, whoever of the gentleman has expired. For what purpose does Mr. Benz seek recognition?
Let's strike the last word.
Gentleman is recognized.
Thank you, Mr. Chair. And of course, the failure of the bill is it's trampling on due process. And with that, I'll yield to Mr. Roy.
I thank the gentleman for yielding. My name has been invoked a few times here. I would point out that the criticism alleged that that there being any Supreme Court precedent or support of any kind for the premise that people have a right to defend against tyranny, I would just submit the Declaration of Independence itself. That to secure these rights, governments are instituted among men, derive their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. Now, we could sit here and go on, and I'm sure Professor Raskin would enjoy doing that, and I would enjoy having that conversation, and happy to have that conversation with you over a beer about what that means, and what that means in 2021. But what it certainly means is that all power comes from the consent of the governed. And what we're doing here is dangerously upending that in this country. That's the truth. The truth is we're turning our institutions on their head. We are eliminating the confidence of the American people in our institutions. Whether it's Dr. Fauci not wanting to acknowledge what's going on with gain of function, whether it's the CDC not wanting to acknowledge natural immunity, whether it's the FDA blocking access to new drugs in Merck and the HHS cutting off access to monoclonal antibodies in Texas, whether it's the Attorney General of the United States targeting parents and focusing on trying to go after parents in school board meetings and refusing to back away from that, even when the National Association of School Boards backs away from their own memo that served as the basis for it. Whether it's a Secretary of Homeland Security or a President of the United States who is literally refusing to willfully execute the laws of the United States on our southern border, specifically refusing to execute Title 42, Migrant Protection Protocol, do whatever it takes under the law to secure the border, to protect the citizens, and fully abandoning that. We are upending our entire order and creating a situation where you have the governor of Texas having to say he, as governor, is going to have to figure out how to defend the border of Texas. And no doubt my learned colleague from Maryland would question whether he has the authority under the Supreme Court's Arizona decision to enforce federal law when the federal government is actually abandoning its duty under the law to secure the border of the United States. But that's what's happening. It's directly what's happening. And not one of my colleagues has been able to refute that once in any of the conversations we had about that. Not once. When we've got tens of thousands of people pouring across the border, 70,000 who have been paroled or been sent out with notices to appear. And my colleagues are shaking their hand, but they can't refute it. It's literally irrefutable because of what we're seeing happen at the border. And when my colleagues talk about, oh, well, with respect to tyranny, whether or not the Second Amendment is to be used to push back on tyranny, that takes forms in a lot of different shapes. It doesn't create a right of revolution against tyranny, but what it does is empower individuals, as my colleague just explained. How about in the summer of 1965, when 20 black Army veterans in Jonesboro, Louisiana founded an armed community defense patrol, the Deacons for Defense of Justice, inspired by a visible public presence of boldly armed men, black attitudes in Jonesboro began to change. Black housekeepers stopped accepting racial taunts and quit if the taunts continued. The Deacons' model spread to other Klan heartlands. In June 1966, after the attempted murder of civil rights leader James Meredith, major civil rights organizations banded together to continue the Meredith March Against Fear. As the Deacons' example demonstrates, resistance to tyranny does not have to rise to the level of state militias attempting to oust the national dictator. But what it does is it says that the people are sovereign. The people are those from whom all power emanates. And that is what my friend from Maryland knows. And he knows that. And he wants, I'm going to finish, my name has been invoked a number of times. I'm going to finish my time just to say, at the end of the day, these are important questions that we must and should wrestle with. The rule of law governs. And anybody who takes on and attacks an institution or attacks a member of law enforcement should be prosecuted to the fullest extent of the law. But at the end of the day, if the people are going to be sovereign, the Second Amendment is the strongest barrier and protection of their ability to maintain.
Time of the gentleman has expired.
I yield back.
For what purpose does Ms. Dean seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I might be confused, but I am pretty sure we were supposed to be talking about that which would reflect anything that has to do with the worthy legislation that we are marking up today by the gentlewoman, Ms. McBath. I find this conversation incredibly shamefully a set of talking points that has literally nothing to do with this worthy legislation. Legislation that will save lives and not interfere with constitutional rights. Legislation that was crafted thoughtfully, educated, in a way that is constitutional and protects constitutional rights, but would literally save lives. I find it astonishing that folks on the other side of the aisle are using this to spew misinformation, disinformation that is not germane to the bill whatsoever. I am not sure what school board decisions, as I read from this amendment, have anything to do with the red flag laws that we are trying to pass that would simply save lives. Families need this tool. It is shocking to me. And with that, Mr. Chairman, I yield to the gentlelady, Ms. Jackson-Lee.
Let me thank the gentlelady for yielding, and I guess I'm always defensive on the great work of the Judiciary Committee under Chairman Nadler, and privileged to be the chair of the Subcommittee on Crime and the great work that has come under the subcommittee as it relates to criminal justice reform, which really stuns me. My good friend from Texas, I'm certainly stunned by your access to Google facts and the historic facts that you seem to be offering. But let me be very clear and concise. I'm not a professor yet, Professor Raskin, but I do want to distinguish in what I believe your argument was, is that what we saw on January 6th was tyranny, distinguishable from First Amendment rights. I don't think any of us have ever stopped the expression of discourse, dissent in this nation. I would surmise that there are a number of us in this room that have been on more than one picket line in our lifetime and expressed dissent. This amendment is by its very existence unnecessary, because the First Amendment is constitutional and all of us are able to adhere to it if it is violated. We are talking about the red flag laws. I'm not sure what the gentleman said. I heard something about black people, and I'm always wanting to make sure that we're all part of the human family, the beloved community. But I certainly don't want us to be juxtaposed against undermining red flag laws. Because if there are ever individuals that have been victims of gun violence, it ranges in the people of color. And therefore, our families need help as others do. The simple underpinnings of this legislation has nothing to do with the First Amendment. It has really nothing to do with the Second Amendment, because you are constantly using the term sovereign. I know what that means. You are constantly surmising that the nation will rise up against you. And a letter from an attorney general is not the nation rising up against you. It is a simple process to bring order to the process of school boards, teachers, family members, and others coming before the board for their children. And the underpinnings of this sovereign terminology is that we're at war with our nation. And that was the premise of January 6th. You were at war. They were at war with the political body, the United States Congress, members of Congress doing their duly elected responsibilities. And in that instance, are you suggesting that they, in their violent dissent, had the right to beat up police officers and put them in hospitals? Because that's what it seems like the argument is. Again, it is a distraction from what we're discussing now, which is to help families, to help human beings, to help Mr. Cruz, the Parkland shooter, who, if we had only exercised those red flag laws that may not have been in place at the time. So I would ask my colleagues to oppose the amendment and to recognize that the underlying bill is simply what it is, to save lives, not a discussion of sovereign
Time of the
powers,
gentlelady has
but to
expired.
save lives. I yield back.
For what purpose does
I yield
Mr.
back to the gentlelady for her kindness.
Her time expired. For what purpose does Mr. Bishop seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I think here at the end, I'm not sure how many more have an opportunity to speak or time to speak left, but I think since the question's been posed so often about how far we've strayed from the purpose of this bill, let me go back to how simple this amendment is. The bill is about when a federal court can strip citizens of their Second Amendment rights, take their firearms from them. And the bill lists several factors that the court may consider. All that this simple 3 1/4 line text addition would do is to say that the court, quote, may not consider activities protected under the First Amendment to the Constitution, including parents voicing concerns about school board decisions. Not exclusively that, including that the court may not consider someone exercising their First Amendment rights as predicate to strip gun rights from them. Now, if that's unnecessary in the minds of some, it certainly is harmless to the bill. And yet the fight has raged and watch, behold, every Democrat will vote against that expression of protection of the First Amendment rights of the citizens. One member just said it was shameful to talk about this when this is so imperative that we pass this bill stripping Second Amendment rights. It's shameful to talk about. Let me tell you something. The National Association of School Boards found shame after they sent a letter maligning and defaming parents across the country for exercising First Amendment rights, defaming them as domestic terrorists. They understood what shame was when someone took control there, and they apologized. What did the Attorney General do today? He doubled down. What is the majority on this committee doing? Doubling down. Moms and dads across the country, look at this carefully. Watch what is happening, because they're going to vote right now to defeat an amendment that merely says a court will disregard your expressions of your First Amendment rights when it is deciding whether it will take your guns away. And with that, I look for any who might want time. Seeing none, I yield back.
The gentleman yields back.
Mr. Chairman.
In that case, the question occurs on the amendment. For what purpose does Ms. Deming seek recognition?
Move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, when my colleagues on the other side of the aisle are explaining that they did not mean that it was okay to kill members of law enforcement or members of the military, I think we have a much greater problem than this legislation. So I'm going to not be tempted to engage in such a ridiculous, meaningless conversation that I'm hearing from the other side of the aisle. I'm going to yield to the gentleman, Mr. Cicilline.
I thank the gentlelady for yielding, and I just want to make a very brief point. I think we owe it to the victims of gun violence, people whose families have been just destroyed because someone exhibited dangerous behavior and their family member would be alive today if a red flag law were in place. That's what this legislation is designed to address. We owe them the respect, the victims of gun violence, to debate this bill on the merits. This has been like a Fox News bingo form. Election fraud, Dr. Fauci, border activity, defunding the police, socialism, trans bathrooms, and parents at school board meetings. Bingo! You hit it was a potpourri of every crazy talking point. Let's get back to this bill. Let's show the sponsor the respect that the victims of gun violence deserve in this country. Either support it or oppose it on the merits. Stop talking about all this nonsense and focus on the legislation. I yield back to Ms. Demings and thank her for the time.
Thank you so much, Mrs. Cicilline. Mr. Raskin, I will yield to you if you would like the time.
Well, thanks to the gentle lady. I would just echo my colleague in saying we have seen nothing but a succession of distractions and diversions from a very serious legislation that our colleague from Florida has brought forward. This is working in 19 states. It's working in the District of Columbia. There are a lot of people who have engaged in gun violence who have given a tip-off to the people around them, to members of their family, and this simply extends this policy to say that those people can go to court to demonstrate, if they can show with probable cause, that the person is a danger to themselves or to someone else. And yet, inevitably, it has become an occasion for a series of Fox News talking points. Yeah, I'm just sorry that the legislative process has been degraded in this way, and I yield back to you.
Mr. Chairman, I yield back.
Mr. Chairman.
The gentlelady yields back. For what purpose does Mr. Shabbat seek recognition?
Move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you, Mr. Chairman. I want to thank the gentleman from Wisconsin for offering what I think is really a common sense amendment that everybody ought to support, although I know none of my Democratic colleagues will do that. But, what it essentially says is that you can't take away somebody's Second Amendment right for merely exercising their First Amendment right. And in this case, of course, it's exercising that First Amendment right at the school board meeting. Now, it might seem ludicrous that anybody would try to take away somebody's First Amendment right at a school board meeting, and I would have initially thought that was the case, but we saw just last week that that's exactly what the National School Board Association was trying to do, and the Biden administration was essentially going along with it. And we want parents, as a former school teacher, and I mentioned this last week at the hearing, as a former school teacher, I know from experience that children do best when their parents are involved in their education. So we want those parents involved. We don't want to prosecute them. We don't want them to be held responsible or liable for merely speaking out on an issue that they care about their kids' education. And the logical place oftentimes to do that is at a school board meeting. That's been happening for years across this country. But when you have controversial subjects like critical race theory, and in some cases it's the matter that's in books, some parents care a great deal about that. They have a right, every right, to speak up at those board meetings. They have no right, of course, to be violent. And if they're violent, local law enforcement can handle that. We don't need the federal government. We don't need the FBI. We don't need the Justice Department using, for example, the Patriot Act to go after those parents and to try to cut off their First Amendment rights by essentially declaring them domestic terrorists. And some of my Democratic colleagues laugh at that, and to some degree, the Attorney General last week denied it. But that's exactly what was happening, and we all know it. So in this case, I think Mr. Fitzgerald is exactly right to make it very clear that you're not going to take away somebody's Second Amendment rights, which to a lot of people are very important. Some not so much, but for most of us, yes, Second Amendment rights, it's in the Constitution, very important. We ought not to jeopardize their Second Amendment rights for merely exercising their First Amendment rights, in this case, at a school board meeting. So I commend the gentleman for offering this amendment. I would urge my colleagues to support it. And
Gentleman yield.
I'd be happy to yield.
I thank the gentleman for yielding. I just want to, I mean, again, we've heard from the Democrats, this is frivolous, it's a distraction, it's a diversion. This goes to the heart of the issue because it's about liberty, it's about basic constitutional rights. I just want to read, I asked earlier to have this entered into the record, but I want to read from the Ohio School Boards Association letter to the National School Boards Association. Second sentence, the Ohio School Board Association will not continue its membership in the National School Boards Association. Next paragraph, OSBA, Ohio School Boards Association, decision to terminate membership and affiliation with the National School Boards Association is a direct result of the letter sent by the NSBA, the national boards, to President Joe Biden late last month. The letter reported to be sent on behalf of state associations and school board members across the nation. Next sentence is important. This assertion could not be further from the truth. In other words, this group here in Washington acted on their own. This assertion could not be further from the truth. The Ohio School Boards Association was not notified of the letter, nor were we asked for our thoughts on the matter. If we had been consulted, we would have strongly disagreed with the NSBA's decision to request federal intervention as well as your claims of domestic terrorism. That's as strong as it gets. This is a group acting on their own for politics, and the Attorney General is going to implement exactly what they said. And all this amendment says is, as the two previous speakers on our side said, if they're willing to go after your First Amendment liberties, now they're going to go after your Second. We better be aware of all this. That's all this amendment does. I hope we vote yes. I yield back.
Thank you. Reclaiming my time, defending the First Amendment and the Second Amendment of the United States Constitution are not distractions. And I yield back.
The gentleman yields back. Is there anyone desiring time? If not, the question occurs on the amendment. All those in favor say aye.
Aye.
All those opposed, no. All those opposed, no.
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 Opinion of the chair, the noes have it.
Madam Chair, could I get the yeas and nays on that, please?
A recorded vote, the yeas and nays are requested. Clerk will call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Stimmings?
No. Jayapal votes no.
Ms. Jayapal votes no. Ms. Stimmings votes no. Mr. Correa?
Correa votes no.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe? Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy? Aye. Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Benz?
Yes.
Mr. Benz votes yes. Mr. Owens?
Aye.
Mr. Owens votes aye.
How am I recorded?
Mr. Nadler, you are not recorded.
No.
Mr. Nadler votes no.
Oh, this is
Mr.
Bass.
Chair.
How am I
Ms.
recorded?
Bass?
How am I recorded?
Ms. Bass, you are not recorded.
Bass votes up. No.
Ms. Bass votes no.
Mr. Jones?
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
I am a no.
Mr. Jones votes no.
Anybody else? Is there any other member who wishes to be recorded who hasn't been recorded? The clerk will report.
Mr. Chairman, there are 19 ayes and 23 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in nature?
Mr. Chairman.
For what purpose does Ms. Jackson Lee seek recognition? Without objection. For what purpose does Mr. Stube seek recognition?
I have an amendment at the desk.
Clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2377, offered by Mr. Stube of Florida, page 18,
Without
line
objection, the
25.
amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. My amendment would provide an award of attorney's fees for the defense of false or frivolous petitions. When I was in the legislature in Florida, I opposed the state's red flag bill, but it was passed and signed into law. As a result, my state has seen the many ways these laws fail to achieve their goals and violate the Second Amendment rights. My amendment today addresses just some of these failures. And I've spoken to many attorneys who practice in Florida where this has become a significant issue and a significant cost to those who have wrongly had their firearms taken away. Red flag laws like the one before us lack due process and procedural protections. In the states, there have been rampant violations of Second Amendment rights due to this lack of basic legal protections. In Florida alone, gun owners with similar names have been mixed up and the wrong person has lost their firearms. Gun owners subject to red flag petitions have been given incorrect information about their administrative hearing location. More concerning, quarreling partners and family members have weaponized red flag laws in domestic disputes. On top of that, studies show these laws do little or nothing to reduce violence. A study by the Crime Prevention Research Center found that red flag laws had no significant impact on murder, suicide, the number of people killed in mass public shootings, robbery, aggravated assault, or burglary. I'd also ask for unanimous consent to enter into the record, do red flag laws save lives or reduce crime? By John Lott and Carlisle Moody. Additionally,
Without objection.
Thank you. Additionally, there are already mental health statutes on the books, especially in Florida, like the Baker Act, that better address potentially dangerous individuals while also providing appropriate procedural protections. My amendment should be common sense for all of my colleagues, whether they support or oppose the underlying bill. It simply allows for an attorney's fee award in response to a false or frivolous petition. The underlying bill drags average American gun owners into court to defend their constitutional rights against government infringement, and it does so without paid access to counsel at the proceedings. Additionally, while this bill does create penalties for anyone who files false or frivolous petitions, I remain doubtful that left-leaning law enforcement agencies like our current DOJ would ever apply these penalties and prosecute anyone. My amendment would provide an avenue for some gun owners to get reimbursed for the cost of counsel at sham red flag hearings. Some of the attorneys that I've spoken to in Florida that have handled these cases have said that it costs upwards to about $10,000 in attorney's fees for petitioners to get their guns back. If an agency takes and confiscates a firearm wrongly, the individual has to then petition the court because a lot of these law enforcement agencies are not willing to give back firearms without a court order. My amendment would provide an avenue for some gun owners to get reimbursed for the cost of counsel at sham red flag hearings. Additionally, my amendment would provide a way for the victims of false and frivolous petitions to sanction those who filed the petition, even if authorities decline to pursue criminal charges. This is not all that different from Rule 11 in federal civil procedure or similar rules under every state's civil procedures. It should be non-controversial and common sense. This amendment does not fix all of the problems with the underlying bill, but it helps fix some of the glaring failures with this dangerous and unconstitutional piece of legislation, and that is the amendment, Mr. Chair.
Gentleman yields back. I recognize myself in opposition to the amendment. If you will look at page 18 of the bill, it reads as follows. Penalty for false reporting or frivolous petitions: an individual who knowingly submits materially false information to the court in a petition for a federal extremist protection order under this section, or who knowingly files such a petition that is frivolous, unreasonable, or without foundation, shall be fined not more than $5,000 or imprisoned not more than 5 years, or both. So this amendment is both unnecessary, since there is a very considerable criminal penalty for anyone who does this, and attorney fees, well, I'll leave it at that. It is unnecessary because to assess reasonable attorney fees. By the way, someone who is sued under this and needs an attorney will have an attorney assigned to them by the court at this point anyway. So I oppose this amendment as completely unnecessary. I yield back. For what purpose?
I withdraw my point of order.
Point of order was withdrawn. I yielded back. For what purpose does Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you. The problem with the logic of the chair is that while this has a deterrent facility in it by criminalizing or providing a penalty for someone who raises a frivolous or false claim, it doesn't restore the victim in this instance. And the victim would be the one who is the victim of the fraudulent or false claim. That's why Mr. Stubbe's amendment is so virtuous and so necessary, because it says, all right, if you're going to pass a red flag, how about letting the victim, who has to spend $5,000 or $10,000 or whatever it may be, who knows, who can estimate? They may have to bring in psychiatrists, other legal experts to come in and testify, medical experts. It's going to cost a lot of money. And this would allow them to recover if there is truly a false or fraudulent or frivolous claim. Thus, I support this rather common sense restitution to victim amendment that Mr. Stubbe is offered, and I'll yield time to Mr. Gates of Florida.
Yeah, I appreciate the gentleman for yielding. I would suggest that my colleague from Florida could be even more ambitious by suggesting treble fees in damages. If we really want to deter the frivolous claims, this seems like the most modest and reasonable way to do so, tracing Rule 11. And that's why it makes sense and would conform to other laws under this posture. I yield back to the gentleman from Arizona.
Thank you. Now yield to the other gentleman from Florida, Mr. Stubbe.
Thank you, the gentleman, for yielding. So the way that, I can't speak to how other states work, but in response to the chairman's contention that the bill deals with this issue, it absolutely does not deal with this issue. Here is how this plays out in real world, in real life, and has played out in Florida. A law enforcement officer gets a call in a domestic situation from a spouse or an ex-boyfriend or girlfriend or whatever the case may be, and that law enforcement officer makes a decision based on the red flag laws in Florida to confiscate an individual's guns. Later, it's determined that that individual's guns shouldn't have been confiscated. There's actually some instances that I briefly touched on and could give a lot of different examples of people with similar names who have had their guns stolen because the police went to the wrong place because the names were the same. What then has to happen once the firearms are in the possession of the law enforcement agency is the individual has to hire a lawyer to petition the court in that jurisdiction to get an order from the court demanding that the law enforcement agency give back the firearm. If the individual who wrongly had their firearms taken from a sheriff's department goes to that sheriff's department and said, you wrongly took my guns, there was no charges criminally filed against me for a violation of the crime, that law enforcement agency is not going to give those guns back without a court order. So that individual has to then hire a lawyer to petition the court to get a court order to then order that law enforcement agency to return that firearm that was taken without a warrant, without sometimes in this case, without due process, and sometimes without probable cause because you're asking a law enforcement officer to just make a determination. So what this amendment simply does is says if there's a circumstance that happens like this, is we're going to allow for a reasonable attorney's fees provision for that individual to be able to pay his lawyers to get his firearms back. And this disproportionately affects low-income and middle-income individuals who don't have $10,000 to be able to spend and pay for a lawyer to get their guns back. So especially in your high-crime, low-income areas, disproportionately disadvantaging those individuals because they don't have a $2,500 retainer to pay a lawyer to then represent them, to petition the court, to get an order from that court to get their firearms back. So what happens in those circumstances is those individuals who wrongly had their firearms stolen or taken by law enforcement without a warrant, without due process, then have no financial ability to go back and get their firearms back. This amendment would simply allow that if that circumstance have occurred, and it has occurred in the state of Florida, that individual would have reasonable attorney fees paid for by the agency that wrongly took his firearms, so they don't have to hire an attorney to do that. I yield back to the gentleman.
Thank you. Now yield to the gentleman from North Carolina, Mr. Bishop.
I thank the gentleman, and I suppose it is in order to observe that the circumstances the gentleman from Florida just described would make this bill as proposed systemically racist. It seeks to impose disproportionate burden on those.
The time of the gentleman has expired. Who seeks recognition? For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chair, I would strike the last word and
Gentleman is recognized.
yield time to my good friend from North Carolina, Mr. Bishop.
Disproportionately burdens those who are least able to bear the burden. And it is telling, isn't it, in the context of this bill, which over the course of all of the other debate, what has recurred as a theme over and over is the degree to which it disregards the interest of the person whom the Constitution vests with a fundamental right. Excuse me, let me make sure I say that right. The Constitution protects an existing fundamental right. And over, that is disregarded. So when the chairman says he opposes the amendment because this is fully provided for, unnecessary, because prison time or a fine will inure to the benefit of the state. The state is fully protected, but the individual is out of luck again. What do you know? I yield back to the gentleman from Wisconsin.
Reclaiming my time. The other thing I just offer some perspective on is that not only are the costs associated with this, as Mr. Stubbe has laid out, I think, very well, but in Wisconsin, I went through this in the 90s, and it was related to any domestic abuse cases where it was in statute that it basically said those firearms must be turned over. And I think a lot of members, when they think about this situation, they're thinking about one firearm. They might be thinking about a pistol or a revolver that individual has. But I know in my district, in the 5th Congressional in Wisconsin, and throughout the state, I'm not exaggerating when I tell you that there are many people, constituents of mine, who are sportsmen, who also do target shooting, who use firearms in a number of different ways. They may have 100 firearms in a safe, locked up securely in their home. Now, there has to be some place to move those firearms for a temporary amount of time, as the statute would prescribe. And I know what happened in Wisconsin. Many of the sheriffs, they didn't want to touch them. They didn't want their hands on these individual guns and rifles because they would have to accept the liability for the care of those and the storage of those. If you think about that, what's a sheriff going to do with those individual firearms? What's a chief of police going to do with them? So what happened was the judge started to order that they be turned to another family member. And it created chaos. It created a mess. So my point is, I think there's a lot of long range and other ancillary items associated with this that I don't know that it's really been thought through. And it's another reason, I think, to support this and any other amendments that would modify what I think is obviously an extreme overreach. And I would yield back.
Gentleman yields back. Does anyone else seek recognition? In that case, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no? No?
No.
In the opinion of the chair, in the opinion of the chair, the noes have it.
As for a recorded vote.
The recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? No. Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Dimmings? Ms. Dimmings votes no. Mr. Correa?
Correa votes no.
Mr. Correa votes no. Ms. Scanlon?
No.
Here.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Nagoose?
No.
Mr. Nagoose votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross? Ms. Bush?
No.
Ms. Bush votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert? Mr. Gomert votes aye. Mr. Issa? Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe? Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Am I recorded?
Yes.
Ms.
Mr. Chairman,
Fishbach votes yes.
how am I recorded?
Ms. Sparts?
Members should wait till the end of the roll call to ask how they recorded.
Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Mr. Jeffries?
Jeffries votes no.
Mr.
Mr.
Jeffries
Deutsch?
votes no.
Mr. Deutsch?
Mr. Deutsch votes no.
I think that's
Mr.
Steve
Cohen? Mr.
Mr.
Issa?
Chairman, how am I recorded? I want to vote, this is on the amendment, I vote no.
Mr. Cohen votes no.
Mr. Issa?
Thank you, Mr. Chairman. Yes, please.
Mr. Issa votes yes.
Mr. Jones?
Mr. Jones is a no.
Mr. Jones votes no.
Are there any other members who wish to be recorded who haven't been recorded? The clerk will report. Does Ms. Ross seek recognition to be recorded?
Yes. Mr. Chairman, how am I recorded?
Ms. Ross, you are not recorded.
Ross votes no.
Ms. Ross votes no.
You got everybody? The clerk will report.
Mr. Chairman, there are 18 ayes and 24 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? For what purpose does Mr. Massey seek recognition?
Mr. Chairman, I have an amendment at the
I
desk.
reserve a point of order,
The
Mr.
clerk
Chairman.
will report the amendment, and the clerk, point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2377, offered by Mr. Massey of Kentucky, page 24, line 6.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This is a very simple amendment. It's just common sense, I believe. The underlying bill itself has an annual reporting requirement to report on the number of red flag orders or extreme risk protection orders by race, ethnicity, national origin, sex, gender, age, disability, and English language proficiency. I presume this report is required in the bill to make sure that there are not racial disparities in the right to bear arms as a consequence of these red flag laws. And it's right to include these reports in the underlying bill. And so therefore, it would also be correct and advisable to have this same report issued by the Attorney General on the National Instant Criminal Background Check System. So what my amendment does is it says, in addition to issuing this annual report on the various effects across race, ethnicity, sex, age, disability, in addition to doing that for the red flag laws, that we should do that for the NICS, the National Instant Background Check System, to make sure that we don't have racial disparities there. Now, we already actually know there are racial disparities there. The data that we have shows that African-American males are 3 times more likely to be denied the purchase of a firearm at the first point of the check, and falsely, in fact. And the same, and Hispanic males are twice as likely with respect to Caucasian males to be falsely denied in the NICS instant background check system. So we need to get these numbers. We need to figure out how this is happening and how to keep it from happening. And I'm afraid it's probably going to happen in the red flag laws. So it's right that the underlying bill has this report in the red flag laws, but we also need to have the same report in the NICS report. There's one other thing that my amendment does. The categories that are listed for red flag laws in the report include race, ethnicity, national origin, sex, gender, age, disability, and English language proficiency. But I think it should also include average annual income. As Mr. Stubbe wisely pointed out, and that his amendment sought to fix, these things, every one of these laws has a disparate effect and impact on low-income individuals, regardless of race or ethnicity or sex. The threshold that is required, you have to upfront the money, you have to try to take time away from work, even if there was no money involved and no lawyers involved and no filing fees. Just the time away from work is an opportunity cost that many low-income individuals cannot afford. So I think we should also include average annual income as a category in these reports, both for red flag laws and for the NICS report. And with that, I will yield back the balance of my time.
Mr. Chairman?
Does the gentlelady insist on her point of order?
Mr. Chairman, I do insist on my point of order. The report requested is not germane. It is dealing with the NICS on a very broad question of a myriad of demographic factors. I do appreciate the gentleman's concern about race, and I hope that we'll have an opportunity to discuss other race-based discrimination. But in the instance of this legislation, this is about red flag laws. It is not about the extensive report under NICS, and so I insist on my point of order, Mr. Chairman.
I agree with the point of order. I will point. The NICS report is beyond the scope of the bill, and therefore is out of order. The first two amendments, however, the first two parts of the amendment, however, inserting average annual income, are in order, and I would accept them if the gentleman. I would accept them as amendments if the gentleman would agree to separate.
I will agree to withdraw this amendment and substitute another amendment that should also be at the desk, which includes the two provisions that the chairman has agreed to include, which would insert average annual income as a reporting category.
Would it do anything else? All right.
I would like.
Fine. The amendment is withdrawn. The clerk will report the next amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to HR 2377, offered by Mr. Massey of Kentucky, page 24, line 6. Insert after disability the following: average annual income.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
This amendment is very simple. Look, the underlying bill includes reports based on race, ethnicity, national origin, sex, gender, age, disability, English language proficiency. This would add average annual income as a reporting category, and that is necessary, just like the other categories are necessary. We know in the NICS background check system.
Would the gentleman yield?
I would yield to the chairman.
We will accept this amendment. We have no reason to oppose it. We will accept this amendment.
I withdraw my
Well,
point
the
of order.
point of order is withdrawn.
Chairman, if you.
Point of order is withdrawn, and we accept the amendment.
Well, they say when you have the sell, quit selling, but I'd like to keep selling if I may.
Gentleman has the floor.
All right, reclaiming my time. I think this is an important category to include, and I appreciate the chairman recognizing that. The reason these reports are important, and the reason that I think we also need these reports for the instant background check system, is we do know there is racial disparity in the application of this law. It's not intended, but there are things that could be done to prevent the racial disparity, like in the instant background check system. We could use something other than similar spelling of names and similar birthdays to check. And all of these laws have underlying implications. The ramifications are that they are racially disparate in the outcomes. They are going to be disparate also in the outcomes for income. And these are some of the most regressive laws that we can put on the books. It's especially concerning because this is a fundamental constitutional right as ruled by the Supreme Court and is laid out by founding fathers. And your income should have no effect on your ability to keep and bear arms. When we see fees charged, for instance, to get a concealed carry permit, if you have a state that has a fee that's $100 or more, we see that concealed carry permits are issued far less frequently, not to the people who can afford it, but to the people who can't afford it. So income disparity is a very important category, and I'm glad that the chairman recognizes the importance of reporting this, and I hope that what they will find out, of course, I hope this bill does not pass. I'm going to vote against it, but I hope what we find out from these reports will tell us that these laws have a racial and income disparity in terms of their application. And I yield back the balance of my time.
The gentleman yields back. I hope we can go to a vote. All those in favor say aye. Aye.
Aye.
Opposed, nay. The ayes have it, and I hope no one will call a roll call vote. The amendment is agreed to. Are there any further amendments to the amendment in the nature of a substitute?
Mr. Chairman,
For what purpose does Mr. Stube seek recognition?
I have an amendment at the desk.
Gentlemen, the clerk will report the amendment.
Reserve a point of order, Mr. Chairman.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2377, offered by Mr. Stube of Florida. Page 6, line 17.
Without objection, the
I
amendment
reserve a
is
point of order.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. Under this bill, without even alleging any criminal activity, someone can have an individual's firearms and ammunition confiscated. The current evidentiary standard to obtain an ex parte order in this bill is probable cause. Probable cause is an unbelievably low standard to deprive an individual of his or her constitutional rights without an allegation of criminal activity or an opportunity to be heard. This amendment would raise every evidentiary standard from probable cause and clear and convincing to beyond a reasonable doubt. If we're going to deprive an individual of their constitutional rights without an allegation of criminal activity or an opportunity to be heard, then the highest evidentiary standard should be applied in this bill. That is the amendment. I yield back.
The gentleman yields back. I will, does the gentleman insist on his point of order?
I do not.
The gentleman does not insist on his point of order. The point of order is withdrawn. I recognize myself in opposition to the amendment. The amendment, the standard in the amendment of imminent.
Standard in the bill.
In the bill. Standard in the bill. I believe the existing standards in the bill are adequate, and we do not need to add these standards and the content of this amendment and make the bill more complicated. The existing standards in the bill are quite adequate to the task, and I yield back. Does anyone else seek recognition? For what purpose does Mr. Issa seek recognition?
Chairman, I move to strike the last word.
Gentleman is recognized.
I just came back from Foreign Affairs Committee, and I felt obligated to update the chairman. For whatever reason, the interpretation of the attending physician not only is not the same in the U.S. Senate, where on the floor they're not wearing masks, but I was in Foreign Affairs. None of the witnesses, sitting almost in identical positions to the three staff here, wore masks during the entire hearing. I might suggest strongly that we again go back to the attending physician for an opinion, because there doesn't seem to be uniformity between the House and the Senate or from committee to committee. And the reluctance of members to come to this committee because of the mask rule seems to work to the detriment of the speed and congeniality, if you will, that we would hope for here.
The gentleman yield?
Of course, Mr. Chairman.
We will be happy to consult the attending physician again. I wasn't aware of the disparity of the difference with the Senate. We'll be happy to consult with the attending physician again, but meanwhile, it's incumbent on everyone in this committee, unless they want to appear virtually, but everyone in this committee who's here to wear masks. And as I said, I will not recognize anyone who doesn't. And I see one person not wearing a mask, you should put it on.
Well, but you can't recognize me with it on very well, but
No,
it's
but
me.
Mr. Stubbe's not wearing his mask, and if he seeks recognition.
Perhaps he's going to talk. But reclaiming my time, Mr. Chairman, I know that the work we're doing here is important, but I strongly would recommend that we look at, for example, last night, and I know I'm taking time of the committee, but last night I was at a dinner with virtually, I don't know, 3/4 of the members of the Senate and a large group of members of the House, most of the Foreign Affairs Committee members, and the Japanese ambassador, and a host of other people from the administration. And we all sat around the dinner table, as close as Mr. Gohmert and I are, without masks. They did require that we have a test, and they did require that we be vaccinated or have a current test. The reality is there are procedures that would allow members to be close together to do these things. And although I haven't been in your ante room, I would suggest that you would find in most of the ante rooms the masks come off when they leave. So rather than continuing to do this, I would hope that we would reach out to the attending physician and at a minimum ask if we could be treated as senators.
Would the gentleman yield?
Of course, Mr. Chairman.
I've already said we will reach out to the attending physician. End of story.
I know, but taking yes for an answer, I've got another minute and 56 seconds. Thank you, Mr. Chairman. I yield back.
The gentleman yields back. Who else seeks recognition? For what purposes does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
Wait a minute, we're still on the Stubbe amendment. If no one else seeks recognition, we'll go to a vote.
Mr. Chairman,
Who seeks recognition?
this is Massey from Kentucky.
The gentleman is recognized. For what purpose does the gentleman seek recognition?
I wish to speak in support of the Stubbe amendment.
Gentleman is recognized.
I would just note that there are several sheriffs who have already announced their refusal to implement these red flag laws because they are dangerous to their deputies. To go into a situation, and in many cases unannounced, or in most cases unannounced, and in a lot of cases early in the morning, before the person being served or the person whose weapons be taken away is even awake, these law enforcement officers are sent into a very difficult situation. They're going to agitate the individual. They know the individual is armed. And a lot of sheriffs are saying, we're not going to do this. We're not going to enforce your red flag laws because they put our deputies in a dangerous position. And that is why Mr. Stubbe's amendment is so important. Why would you want to endanger somebody's life just on a suspicion? It needs to be beyond a reasonable doubt. There needs to be a high standard before you're going to put the lives of deputies and other law enforcement officers at risk by agitating individuals unannounced who have firearms. And so I would urge those in this committee to vote for the Stubbe amendment. And if he wishes more time to speak on the amendment, I'll yield to him. Otherwise, I will yield back. I yield back the balance of my time.
The gentleman yields back. Does anyone else seek recognition on the amendment? If not,
Mr. Chairman,
For what purposes Ms. McBath seek recognition?
Mr. Chairman, I seek to strike the last word.
The gentlelady is recognized.
Thank you so much. This bill establishes firm due process protections for respondents. Both the short-term and long-term orders require a high standard of proof. This bill has significant due process protections. In the ex parte proceeding, ex parte orders require a showing of probable cause, and probable cause is a standard that we must use for other meaningful law enforcement actions, such as allowing law enforcement officers to obtain a warrant, allowing them to arrest an individual, and allowing them to search a person or property. But there are also additional protections, and I want to let you know, if you're reading this bill, there must be a signed and sworn affidavit. A judge is involved to make the determination of whether the standards are met. The order must be necessary to prevent that harm, and the risk must be imminent. So once again, there are systems, there are processes that are put in place to protect the system of due process. Please read the bill. Let's not try to add anything else extraneous to it. This is a good piece of legislation that saves lives.
Would the
And I yield
gentleman,
back.
would the gentlelady yield?
Yes, I yield to my colleague from Texas.
I want to thank the gentlelady for that very clear and succinct explanation. I want to juxtapose clear and convincing evidence against the unreasonable man standard. This legislation is offered to save lives. It is a tool for family members. It is a tool for people who feel threatened or in danger, people whose life may be at a moment's edge of being lost because some person in desperate need or in desperate need of intervention, desperate need because of intended violence, desperate need because of intended frustration, seeking the only relief they think they can have at the hands of a gun. And the clear and convincing standard is intended to help civilly save lives. That's what red flag laws are. And to insist on a reasonable man standard or beyond a reasonable standard is in fact to take more time to endanger the proposed victim. Again, we started out with the idea that this is to save lives, and it is documented across America that red flag laws save lives, and it is at the hands of guns. It is not to take guns away, it is to save lives. I thank the gentlelady for yielding, and I yield back to the gentlelady.
I yield back the balance of my time.
The gentlelady yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no? No?
No.
In the opinion of the chair, the noes have it.
Ask for a recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
No, no.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No, 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 no.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
Correa votes no.
Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Big ol' I.
Mr. Gomert votes aye. Mr. Isa?
Aye, aye.
Mr. Isa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana?
Aye.
Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube? Mr. Stube votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop?
Yes.
Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts? Ms. Sparts?
Ms. Sparts, we cannot hear you. Ms. Sparts, we could not hear you. You might want to.
Can you hear me now? Sparks
Yes.
votes yes.
Ms. Sparts votes yes. Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Benz?
Yes.
Mr. Benz votes yes. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
How am I recorded? This is Bass.
Ms. Bass, you were not recorded.
Bass votes no.
Ms. Bass votes
How am I recorded?
Mr. Jeffries, you were not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
Mr. Jones votes no.
Mr. Jones votes no.
Are there any members who wish to be recorded who haven't been recorded? The clerk will report.
Mr. Chairman, there are 19 ayes and 23 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2377, offered by Mr. Fitzgerald of Wisconsin, page 12, line 4.
Without objection, the amendment.
Reserve
will
a
be
point of order,
considered-
Mr. Chairman?
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment, and a point of order is reserved.
Mr. Chairman, as I mentioned with my previous amendment, this bill is an unconstitutional red flag law that infringes on the Second Amendment rights while depriving Americans of due process. I do not believe it is possible to draft a red flag law that will hold up to the constitutional scrutiny if it were to come before the Supreme Court. However, it would be unconscionable to let this bill move forward without protecting our service members. We've already seen the other side baselessly accuse members of the military of holding extremist views. The problem is the other side frequently considers anything they disagree with as extremist. Further, the VA has used a patient flag system to identify difficult or non-compliant patients they classify as threats. Veterans often are not notified that they are on this list and have no recourse to appeal. My amendment would protect veterans against this blatant discrimination by prohibiting military service from being considered as a risk factor under this legislation. I urge my colleagues to support this amendment, support our veterans, and I yield back.
I recognize myself. First of all, the amendment, the point of order is withdrawn. Point of order is withdrawn. I recognize myself. This is something we would consider going forward. We're not prepared to do this today. We may very well do it before the bill goes to the floor. And if the gentleman will withdraw the amendment, we will work with him on the way to the floor. Now I yield to the gentleman.
Absolutely, Mr. Chair. I think it's a valid, obviously, I think it's a valid amendment, and it's something that should be considered, and I would certainly entertain that offer and look forward to working with the majority to amend the bill.
So the amendment is withdrawn, and we will work with you going forward. The amendment is withdrawn. Are there any other amendments to the amendment in the nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute as amended. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye.
Aye.
Opposed, no.
Aye.
No. In the opinion of the chair, the ayes have it. A roll call is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Yes.
Ms. Lofgren votes yes. Ms. Jackson Lee. Mr. Cohen.
Aye.
Mr. Cohen votes aye.
Hold a minute.
Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Hello.
Aye.
Hold on a minute.
Mr. Deutsch votes aye. Ms. Bass.
Bass votes aye.
Ms. Bass votes aye. Mr. Jeffries.
We are hybrid, so I've moved to the virtual.
Mr. Jeffries.
Votes.
Someone should shut their mic.
Jeffries votes no.
Mr. Jeffries votes
Sorry,
no.
Jeffries votes aye. How am I recorded?
Mr. Jeffries votes aye. Mr. Cicilline.
Aye.
I'll just do that.
Mr. Cicilline votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Stimmings. Ms. Stimmings votes aye. Mr. Correa.
Correa votes aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Oh, that's right.
Aye.
Ms. Escobar votes aye. Mr. Jones.
Aye.
Mr. Jones votes aye. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert?
Gomer votes no.
Mr. Gomert votes no. Mr. Isa?
Free of mask, I vote no.
Mr. Isa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
Massey votes no.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
No.
Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz?
No.
Mr. Benz votes no. Mr. Owens?
Owens, no.
Mr. Owens votes no.
How am I recorded?
Ms. Jackson Lee, you are
recorded?
not recorded.
I am, this is on the amendment?
This is on the amendment nature of a substitute.
The bill itself?
The amendment in the nature of a substitute, which will be immediately followed by a vote on the bill.
This is, I'm voting aye.
Ms. Jackson Lee votes aye.
Mr. Chairman, this is Corey. How am I recorded, please?
Ms. Bush, you are not recorded.
Thank you. Ms. Bush, yes.
Ms. Bush votes yes.
The clerk will report.
Mr. Chairman, there are 24 ayes and 19 noes.
The amendment is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2377 as amended favorably to the House. Those in favor respond by saying aye.
Aye.
Those opposed,
Aye.
Those opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen.
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries.
Aye.
Mr. Jeffries votes aye. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Stimmings. Ms. Stimmings votes aye. Mr. Correa.
Correa votes aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia. Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert?
Gomer votes no.
Mr. Gomert votes no. Mr. Isa?
No.
Mr. Isa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey?
Massey votes no.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz?
Mr. Benz votes no.
Mr. Benz votes no. Mr. Owens?
Owens, no.
Mr. Owens votes no.
Are there any other members who wish to be recorded who haven't been recorded?
How is Swalwell recorded?
Mr. Swalwell, you are not recorded.
Aye.
Mr. Swalwell votes aye.
The clerk will report.
Mr. Chairman, there are 24 ayes and 18 noes.
Excuse me,
Wait,
excuse me. How did Sparks Group record it?
Ms. Sparts is not recorded.
is Ms. Sparts seeking recognition? The clerk will report.
Mr. Chairman, there are 24 ayes and 18 noes.
The ayes have it. The bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. At this time, the committee will stand in recess until 10 a.m. tomorrow.